Good morning and welcome to the 26th meeting of the Education, Children and Young People Committee in 2025. Can also welcome Ros McCall, who's joining us for today's meeting. The first item on our agenda is consideration of subordinate legislation, the Teachers' Pension Remunerable Service Scotland Amendment 2 Regulations 2025 SSI 2025-197. This instrument is being considered under the negative procedure. Do members have any comments they wish to make on this instrument? No. Is the committee agreed that it does not wish to make any recommendations in relation to this instrument? That is agreed. The next item of business is evidence over two panels on the Children, Care Experience and Services Planning Scotland Bill. And can I welcome our first panel today? We have Stephen Birmingham, Senior Policy and Standards Manager, Children's Hearing Scotland, Matt Ford, Partnerships and Development Director, NSPCC Scotland, Margaret Smith, who's joining us remotely, Services Manager, Partners in Advocacy, Alistair Hogg, Head of Practice and Policy, Scottish Children's Reporter Administration, and Laura Pasternak, Policy and Public Affairs Manager, Who Cares Scotland. Welcome to you all today. As you can see, we have a big panel, 5 of you on it, so a lot to get through with members and your answers. Can I first of all ask, looking at all of your briefings, I think there's largely areas where you are supportive, but areas you would like to see change in this bill. Could you very briefly describe what you like about what's in it and what you would like to see improved during our scrutiny at stage 1 and 2 and 3 if the bill progresses? Mr Hogg, if I can start with you.
I was hoping you might come to me last.
You were opening your book, so it drew my eye over to you.
So what do we like? Well, we like that this is a step forward towards meeting the promise, focusing particularly on the hearings redesign element of the bill. I know there's lots of other parts of the bill, but that's our particular focus, as you would understand. There's a lot that we like about what's proposed, and there's not a lot that we would say we don't like and don't think should be there, but there are some elements that we think might benefit from some changes, some tweaks that might make things a little bit better for us. Things that we like the progressive move to change the obligation on the child to attend a hearing, to remove that obligation and kind of switch it round and so give the tribunal the power to require the child to attend rather than an obligation on the child. We like the intention to strengthen the chair of the hearing. And we can see that the parts in play there are to allow for the kind of separate role of the chairing member and to allow the national convener to remunerate the chair, and what flows from that. And we like the thought that may lead to the recruitment of chairs with particular competencies, skills, experiences, qualifications. We like the flexibility that some of the legislation brings. The single panel member hearings are something that we have some reservations about, but in principle we would be supportive. We think that there are procedural decisions, but we need to be careful about what we mean by procedural and when these would be appropriate. We like the flexibility in relation to interim orders that is introduced in the bill. We like the promotion of the offer of advocacy, and we can see that introduced through the bill at various places and duties placed on different people to make sure that children are aware of what's happening and what their rights are in that regard. There are changes to the referral criteria to the reporter. We need to work that through, but we think that the change will hopefully be a positive one. We like the changes around the ability to exclude people from hearings in certain circumstances. We think that is a progressive move and allows greater flexibility and power within the hearing to take more control in certain situations. And we like the provisions around removal of relevant person status in certain very distinctive circumstances. We also like the principle of trying to improve the process of establishing grounds of referral. But obviously the proposal is quite a new one and relatively complex, so there's a lot to try and unpick in relation to that. But the principle about changing that, we support. We heard a lot of evidence that that in particular is an area of people's experience of hearings that they would like to see change. And actually that resonates with what our own staff told us. The two main things that our staff told us that they wanted to change way back at the beginning of this redesign process were a strengthening of the chair and a change in relation to the grounds process. They're both present. But as I say, there might be some elements that would benefit from some changes that would make it even better.
And I think we'll get into a number of those elements through our questions. Again, if I come to you, Mr Ford, and if there are elements in Mr Hogg's submission that you agree with, we don't need to repeat it, but just a couple of things you think are good, but areas you think we should be focusing on as a committee and Parliament to improve this bill.
Well, thank you, Convener, for the opportunity to speak. On this, our strong interest is ensuring that what we do in this bill helps the hearing system be as good as it can be for all the children who need it to be there for them. And there's been a seismic shift in the hearing system in the last 20 years, where now 27% of referrals are children under 5, 34% of hearings are children under 5, a third of it's business, children under 5, a much larger proportion of the children in the system first came in when they were under 5. So we focus very strongly on how much the bill addresses the need to take account of the unique interests, needs and vulnerabilities of babies and infants. And there are aspects of the bill that we think are very positive. We appreciate overall the intent of the bill and where it comes from. And we see that there are some positives in there which, if strengthened further, would really allow the hearing system to start to fulfil what we all want for it, which is a world-leading child welfare-based system for assuring that children's needs and welfare is paramount. So for us, the positives that are in the bill are the proposals to strengthen the chair, a remunerated chair. We think that those aspects of that could be strengthened further, and that's what we are calling for. We're calling for a presumption for, or a default, that the chair is consistent throughout a child's case, and that there's a duty, however that will be fulfilled, perhaps through the national convener, for that to be in place for children, and that the chair has sufficient capacity and authority and competence, judicial competence, to be able to handle the complexity that comes with the very serious and life-changing decisions that have been made for babies and infants. And we also very much support the idea of creation of role of a specialist panel member. But we think that there needs to be an extra specification there, that where the case is about babies or infants, the specialist knowledge has to be in that area. And I'm glad to say that if we get into discussion on that, we've got more capacity in that respect now in Scotland, I'm glad to say. The expansion of the right to advocacy, we think is obviously hugely positive. We support that. But as it stands, there's the glaring absence of any measures to provide for infants' voice and experience to be represented. And if we get a chance further, I'll say why I think that's important. But as it stands, the group that needs to be understood most, because the stakes are highest, will be those who don't have the automatic right to independent representation. They can't put their hands up. They can't say, I need advocacy or I want advocacy. But their experience is what they've experienced in their short lives, and how they are now needs to be understood by those who are making the decisions. And that understanding that is not, it needs specialist skills. And in terms of I think the final point that we appreciate, and there needs to be more thought, we think, is about timescales overall, because, and again, thinking of it from the perspective of infants, we have 2 decades of lack of progress on improving the length of time it takes to achieve permanency for children. It's 2.5 years. It was 2.5 years 20 years ago. And we've had numerous attempts at reform and improvement, and system improvement, practice improvement. And we have referred to relevant, up-to-date, comprehensive and rigorous research which unpicks some of that and shows that it's actually embedded in the process of the hearings themselves. And it's partly to do with the complexity of dealing with infants and making these life-changing decisions when there are so many competing voices. And it's a difficult matter. But it's also because some of the processes, the grounds processes, do need to be capped. We do need to have a limit on the grounds process. We agree with Sheriff David Mackey, who has argued that it's overly complex as presented. We very much support his assertions on that. But we do agree and think that there should be a 3-month timescale for the grounds process. That on its own could take a year out of the process for some children. You know, that's could be life-changing for an infant. And the last point I'd make about timescales is we're saying if we take the opportunity which the bill presents to really sort of modernise and bring up to date the process as far as babies and infants are concerned, that involves understanding we don't have all the answers on that yet, because the next bit, after you've got the grounds and you've got the child into a process of decision making about whether they stay with parents or they go back into to be adopted, that's very difficult. So there's a balance to be got there, because we have to give adequate time for parents to engage with therapeutic care to see if they can become the parents they want to be, while at the same time complying with the child's timescales and needs for timely decisions about their permanent care, so that they will know where they're going to be their next birthday, because that's different for our parents. So we are calling for a trial to legislate for a safe baby kind of specialism within the hearings system that would test out exactly how to deliver for babies and infants.
Okay, thank you very much. Ms Smith, we'll come to you now.
Thank you. Thank you for the opportunity to speak this morning and for allowing me to do this virtually. Some of what I'm going to talk about has already been brought up, and so it's good to hear that that we're also in agreement with some of the issues. There's a lot about the bill that we welcome from Partners in Advocacy and Support. We support the proposal of the lifelong independent advocacy, and so there's a few things within that we do like, and a few things that we believe need to be brought to attention. As I say, we like the offer of lifelong advocacy, and we like that the bill is seeking to enshrine the rights of lifelong advocacy, to get it into legislation, and especially around care experienced young people, that there will be a continuation of advocacy support for those people who are care experienced. We are keen to ensure that the practice of independent advocacy is protected and properly defined within the bill. We support the Scottish Independent Advocacy Alliance definition of what independent advocacy is and the practice around it, and working alongside the principles, standards and codes of practice. And we think that that's really important to protect that practice of independent advocacy and to define it correctly. We are keen to ensure that with the increase of lifelong independent advocacy, that it is adequately resource current demand for independent advocacy exceeds capacity across Scotland, and so in order to provide meaningful independent advocacy, adequate resources and structural and finances need to be considered in terms of being able to provide independent advocacy. And that's important. Some independent advocacy is bound by criteria, and a lot of people across Scotland that do need independent advocacy aren't able to access it, and it's ensuring that that is considered when offering independent advocacy, as I say, to protect the practice and make sure it is flexible and it is meaningful independent advocacy. We would like to consider providing independent advocacy for those care experience people that are also parents, are also young parents, and the advocacy provision that is needed around supporting those parents that are also care experience with the children's hearings or in all aspects of their life that they need independent advocacy for. And so, as I say, we really support and welcome the proposal to increase independent advocacy and enshrine it in law.
Ms Pasternak now.
Thank you. Thank you again for having myself here today, and I just want to add at the outset that I'm really looking forward to the session we've got with the committee on the 7th of October in the evening with our members, and I think that will be a really exciting opportunity to get their views a bit more directly on the bill. So I think most of you know who Cures Scotland is, but just to kind of remind that we have over 1,700 members, and we are a professional independent advocacy provider. We work one-to-one with care experience people to help them have their voices heard in decisions affecting them, and this is an example of the collective advocacy that we also provide. Our response was shaped heavily by our Lifelong Rights campaign and our Action on Advocacy campaign, which were developed through our advocacy evidence and our participation evidence from our members. But the campaign on Action on Advocacy is also supported by a number of partners that are mentioned in our call for views response. We are really excited that this bill answers the call from 93% of the care experience people we surveyed for independent relationships-based lifelong advocacy. We think that there's a few tweaks that need to be made to make sure that that commitment is on the face of the bill. But we're delighted, and this also echoes back to the Independent Care Review, where there were 5,500 experiences heard around care experience. Children, adults need to have the right and access to independent advocacy at every stage of their care experience and beyond. I think it's also worth just reminding, although I know that you all know, but being in this committee, that the principle of independent advocacy is all about upholding for children and young people Article 12 of the United Nations Convention on the Rights of the Child. And we need to hark back to the logo of the promise, where the heart in the middle was to represent voice. And I think that's why, although obviously this is called the Children Bill, I do see this as a promise bill in some ways. So obviously we welcome the inclusion of a right to independent advocacy, and we are looking forward to engaging more closely to make the tweaks that we think are necessary to ensure that that advocacy is truly independent, as Margaret laid out, and is of the highest quality possible. I think it's also just worth reminding, I've mentioned a few kind of examples of consultation with the care experience community, but for over 50 years there's been decades of demand for independent advocacy through what care experience people have said directly. Our Speak Out member magazine from 1977 through to 14 abuse-related inquiries that called for independent advocacy, and that resource that kind of highlights the information on these decades of demands for independent advocacy and voice to be at the heart of decision-making for care experience people is in the appendix to our call for views. The demand is also echoed by care experience children and young people's peers at the Scottish Youth Parliament. They've recently published their manifesto where it welcomes, it calls on the Scottish Government to enshrine the right to independent advocacy for care experience people of all ages, and that was a product of the consultation of almost 5,000 young people backing the demands of their peers. We feel like this is the first big really big and necessary step to keep the promise so far. Obviously, we don't think that the bill itself can keep the entirety of the promise. There's lots of things that didn't make it to the bill. But we do think that it has, in and of itself, the potential to bring about greater accountability in keeping the promise. And advocacy really is a way to keep the promise for individuals, and we see that day to day with our advocacy workers that are really on the front line with our members. In terms of moving kind of a bit past advocacy, we were also really excited to see the section on extending rights to aftercare for care experienced people that come off their orders before their 16th birthday. This is an issue that was raised by our member Jasmine Kasaya Pilling through a petition, but that was a product of 7 years of her personal campaigning on the issue. I met with her on Sunday. She's just had twins and is doing really well, and they're thriving, and she wanted me to kind of pass on that she wants to thank the government for answering her calls within her petition. She's worked collaboratively for 7 years with the Cure Community Services organisations to get to this stage, and she thinks that it's essential that there's a collaborative approach to delivering that section of the bill. And just harken back to the process of that petition, there was an informal session with that committee with our members and with advocates talking about why it's so important to ensure that there's rights to aftercare for those young people, and to make sure that there's that the eligibility is as linked to the definition of the universal definition of care experience as possible. In terms of things that we would like to see stronger, I kind of mentioned having the definition of independent advocacy on the face of the bill is really important, and I can talk more about that later. I think there's going to be some more questions. In terms of the children's hearing section, we similarly welcome an earlier offer of advocacy, but we feel given the complexity of that section of the bill, there are certain circumstances in which there really needs to be an opt-out offer of independent advocacy, as there is in England and Wales. We feel like this is in relation to children and people subject to offence grounds and deprivation of liberty orders, given the severe rights interferences that these measures cause. We also feel like there's certain sections of the bill that need to be that we need to ensure are brought within the scope of the United Nations Convention of the Rights of the Child, particularly in relation to the aftercare section and the foster care register section, to make sure that you would be able to challenge your rights if they're not being met under those sections using the UNCRC 2014 Act. 2024 Act. And just harking back to one of my initial points about how we feel like this bill is a massive opportunity to bring about more accountability in terms of keeping the promise, which is something that our members have been calling for since it passed in 2020. One of the quotes that always sticks in my head is, "There's been so much talk, where's the action?" And that's why our campaign is named Action on Advocacy. It's time. We feel like it would be really helpful to have an accountability section in the bill through an amendment. We feel like the best course of action is to make sure that there's measures around post-legislative scrutiny, streamlined data collection, reporting and planning, to ensure that the provisions of the bill are fully acted on. The legislation is kept within the focus for the next parliamentary session. This is the second Parliament that's committed and signed up to the promise overwhelmingly, with cross-party support, and we need to, obviously we can't bind the hands of the future government, but we need to make sure that that commitment is sustained. And we need to make sure that accountability for keeping the promise is rooted in primary legislation as opposed to policy rhetoric and FOIs. That's not good enough for our care experience community. So I'll stop there.
Great, thank you very much. And finally, Mr Birmingham.
Yeah, morning convener, morning committee. Thank you for inviting me along today. I suppose from Children's Hearing Scotland's perspective, we welcome the provisions in the bill. As with SCRA, we have a particular focus in terms of children's hearing, so that's the sort of area of our interest and our attention. And I suppose one of the strengths of the hearing system since it was established in the 70s was its ability to evolve and adapt. And we see a number of the provisions in the bill as potentially making a significant improvement to both the experience and the outcome of children that attend children's hearings. And I think in particular the recognition that it's changed exponentially over the last couple of decades. And we're continuing on our journey to shrink and specialise and meet the aspirations of the promise, essentially. The particular anchor recommendation that we welcome is the acknowledgement that we need an enhanced role for the chair. Hearings have become increasingly complex. The legislative landscape has become increasingly complex. The number of people attending hearings has become increasingly complex. The number of papers that a hearing as a legal tribunal needs to consider has grown exponentially over the last couple of decades. So our anchor recommendation in relation to the new role for the enhanced chair, we think will bring a number of key benefits. We think it'll bring consistency into the system, which children and young people have asked for. It will bring continuity. So children and young people have told us many, many times that they don't want to meet a new panel every time they attend a children's hearing, retell their stories to three strangers. So we think the provisions in relation to the enhanced role of the chair will bring continuity. In fact, we know it will bring continuity to the hearing system. We think it will also bring improved accountability in terms of the enforcement of orders. Having chairs, I suppose, involved in a child's case, making sure that local authorities are implementing the orders, and those professional bodies that are responsible for supporting that child are actually doing what they're compelled to do by the legal tribunal, which is the hearing system. We think it will result in a reduction in terms of drift and delay. So we don't want children coming to the hearing system. We've seen over the last couple of decades a promising reduction in terms of the number of children that have come into the hearing system and a reduction in the number of hearings. So that kind of shrink and specialise agenda. We also think there's an opportunity really to amplify the voice of children and young people, and hopefully a lot of what we say today will reflect the views that we've heard from children and young people leading up to this bill. So overall, we think it's a step change, like I said, in terms of improving the children's hearing system. There is a number of areas where we think that the bill could be improved in relation to your question, convener. And they're illustrated in our call for views, which you would have seen, and we can come on to them in more detail if required. I'll perhaps run through, if it's okay, very briefly, the 5 areas where we think there's room for improvement. One is around clarity in relation to the reporter and the chair of the hearing, making sure that they're actually working together to convene the hearing in a way that best works for the child, and that there's the kind of sharing of information and the scheduling of the hearing at a time and a place, and in a way that works for the child, so that their attendance is that they want to attend their hearing. The other one is perhaps not for the primary legislation, but is to have a review of the grounds hearings. Because, like I said, the strength of the hearing system is its ability to evolve and adapt. And some of the language in there is quite antiquated. And as we sort of change, the legislative landscape changes, particularly as we bring 16 and 17-year-olds into the children's hearing system through the Care and Justice Act. We think that that would benefit from a review, particularly involving the views of children and young people. In relation to the new provisions to do with grounds, we did initially find them quite complicated to understand, but we have managed to get our head around them, and I think there's a challenge in there in terms of making sure that the sector and the children and young people in the sector in particular understand the new provisions in terms of the role of the reporter and the grounds. And we think if we're bringing in a new set of, I suppose, a new procedure in relation to grounds in terms of the reporter-led grounds, we welcome that, because we think it will remove the need for grounds to be in front of a 3-person panel. So we think that's beneficial, but we do think there needs to be timescales attached to that provision to avoid the risk of drift and delay. Finally, we've asked for the removal of the requirement in the 2011 Act to do with the gender composition of the panel. So as it stands now, a panel, so far as practicable, should be made up of a 3-person panel, including a man and a woman. And we think that although that was designed for the best of intentions, it was designed at a time when there was concerns from Kilbrandon that panels were made up of predominantly men. And it was at that point a welcome provision. It's now, 75% of our panel members are women. And we don't think that gender should be a consideration in terms of making a decision in the best interest of the child. And I think this is going to be particularly pertinent for us as we move to potentially the enhanced role of the chair and some remunerated posts. So happy to explore them as we go through this morning's evidence sessions, but that's a kind of overview of our position. But broadly speaking, we welcome it and we see it as a step change in terms of improving the children's hearing system.
Okay, thank you all very much. I think that was a good overview, and a number of the points that you've highlighted will be picked up by other members. But I do have to say, 30 minutes for one question. It was my bad by having a very open question, but we won't be able to repeat that with every question. So I'm sure now going to Pam Duncan-Glancy, she will be more direct in her questions and you will be more direct in your answers. Ms Duncan-Glancy.
Thank you, Convener, and noted. Thank you. Good morning, everyone. And I will just get straight to it because of time. Laura, if I just can pick up on something you said earlier, which was there's some things that didn't make it in the bill. Are you able to give us some ideas of what those could be? Because obviously there could be, should the bill get through stage 1, there could be an amending stage at stage 2.
I think the answer is how long is a piece of string. I think I'm sure you'll have read the Promise Scotland's briefing on what could have been in the bill, or it was initially framed as what could be in the bill earlier this year, and there was a lot. And I think we need to acknowledge where we're at in terms of the parliamentary term, and that the priority does need to be strategic and to think about what do we need to ensure is in the bill to make care experience people's lives better within the time that we have to pass the bill. I do think that needs to be the priority. How do we make sure that the bill is going to make care experience people's lives better, and acknowledge the fact that we're not going to get everything that could have been in the bill. Having said that, I do think there's a real opportunity where, if we have an accountability section that includes a provision around streamlined reporting for corporate parents, to not have separate corporate parenting plans and promise plans, or to kind of rejig their corporate parenting plans to cover the promise, but then there's not a consistency across all local authorities of what issues are covered, but to have simpler, more streamlined requirements to help corporate parents know what data and what information in line with the commitments and the promise they need to be providing in their corporate parenting reports to help bring about better accountability for the promise. And that includes areas like education, including exclusion. We published a report earlier this year showing that care experience people are 6 times more likely to be excluded. So obviously, you know, a full section in the bill on education would be welcome, but I also think there's a real opportunity to make sure that we're collecting the data which will help improve outcome setting and planning around education if we ensure that there's an accountability section in the bill. Similarly, we need more data and monitoring of restraint. That's an area that I'd really like to see better reporting on and better understanding of across corporate parents. And I think the kind of opportunities of having more data collection around equalities for care experienced people would really help us move past the data, the really helpful data that was in the promise. But we need to look at whether or not some of the stats that I might refer to later have moved on around inequalities, and I think unless we have that kind of accountability and transparency mechanism built into the bill, then we could be in the same position when it comes to 2030. We really need to make sure we're being more organised about this. So yeah, thank you.
Thank you. I really appreciate that. Thank you. I'll move on now to ask some detailed questions about advocacy, if that's okay. And if it's all right, Laura, I'll start with you, and then I'll move to Margaret. In the bill just now, the advocacy section, largely in section 4, is shaped by a lot of secondary legislation, and also some of the responses that we've had highlight the potential for confusion with section 18 of the bill relating to information on advocacy in the hearing system. Do you have anything that you think needs to absolutely be on the face of the bill? You said a definition. Is there anything else that you think should be in the face of the bill in terms of advocacy? and how do you think it relates to information on advocacy in the hearing system as well?
Thank you. So in terms of what we think should be in the face of the bill, we think Section 4 needs to be amended to define independence as being separate to, for example, I've used the language of the bill here, the lead children's services planning bodies and any care provision contracted by them within the local authority area in which a care experienced person resides or is placed within a residential or secure setting. The inspiration of that has been the definition of advocacy that's in the National Practice Model for the Children's Hearings System since 2020. So that's 5 years, a really well-established legal definition of independence. But that's actually rooted in the Mental Health Care and Treatment Act 2003. The definition really was inspired by that definition, and we've seen that definition can help bring about a more independent voice for the young person that avoids there being conflicts of interest with somebody that's trying to uphold the young person's voice, but at the same time is employed, for example, by the local authority. Say if there are a children's rights worker for the local authority, and there's potentially only so far they can go to uphold the child's rights. So we really think that independence definition is crucial. It's also a necessary safeguard against what we've seen since 2020. Unfortunately, despite the commitments around advocacy, we've seen cuts across the board. We've seen cuts to the provision of independent advocacy as opposed to investment. Obviously that depends area to area, but in some areas there's no longer any provision of independent advocacy for care experienced people, and the only provision that is provided is non-independent, and that obviously I've not asked why that is, but my presumption is that it was to save money. And I think when we're looking at the areas in society currently where we need to be saving money, the children, young people in the most vulnerable situations are not where we should be starting with. It's not a useful starting point. So yeah, I think independence-wise, that's the kind of solution that we've proposed. I'm just want to make sure I've said everything that I wanted to say. I just also want to point to the Scottish Government's advocacy guidance from 2014, which states that the individuals who have a legal duty to act in the best interest of the child or the young person, such as social workers, panel members and safeguarders, should not also act as the child or young person's advocacy worker. I think we need to bear that in mind when it comes to developing the regulations around that provision for the section on lifelong advocacy, but also for the CHS section. And I think we might talk about that a bit more later.
Can I just ask a follow-up on the lifelong point? Do you think we need further information on the face of the bill about when and who has access to advocacy, or do you think regulation is the space to do that?
I think there would be greater clarity if there was more specificity on the face of the bill. However, it would be harder to update the bill. So we know that the definition of care experience is evolving. It has evolved and it's likely to evolve. And I think it could actually be quite advantageous to have those specifications in regulations, and they would be the product of further consultation. Having said that, I do think it's important to keep the word lifelong in. And I think the bill could be even further developed by having the word relationship based in, to kind of guide the regulations that will then be developed. That's such an important principle for independent advocacy for our members. They trust their advocates, and they want to be able to ensure that there's a continuity of relationship and that they're not met with cliff edges in terms of age and eligibility when ageing through the services for care experienced people and onwards into adulthood.
Thank you.
In terms of, just to finish off the question around the CHS, something else we really think needs to be in the bill is that provision around opt-out that is in England and Wales. For us, as I said earlier, like the line in the sand has to be for care experienced people on offence grounds, subject to offence grounds or deprivation of liberty orders, and we think that that would really help guide care experienced people through the hearings process that is so complex, even with the changes proposed by this bill, to understand their rights just from the outset of that process and the consequences of agreeing to grounds, for example, and what that could what impact that could have for them lifelong in terms of their record, in terms of disclosure checks. We really need to ensure that safeguard is in place from the outset.
Thank you. And on that, do you think it should be independent advocacy or legal advocacy?
Both.
Okay.
I think there needs to be opt-out, independent advocacy and independent legal advice. And what happens in terms of the relationship between the two services is the advocate is trained, our training is lawyer-led, to know when to refer to legal representation, and in certain situations that the representation is then provided purely by the solicitor. Or if the child would prefer, both adults can be in the room. It's very much down to the child's view.
Thank you. Thank you, Laura. Before I move to you, Margaret, could I just maybe ask Matt Ford about how that provision or the role of advocacy could work for infants and babies?
I think, our focus is to bring into our thinking that babies and infants need advocacy. And it's not something that it's not a well-established part of our system. And as I said in my opening remarks, we've fairly radically changed the nature of the children's hearing system, but we haven't ever scrutinised what that means for those children. So it would be a whole sort of new set of provision. And I think the first things I would want to say is that it seems daunting to people to think about how can you represent independently the views and experiences of babies and infants that can't speak. And the answer to that is there are a sort of unique set of skills and specialisms, and thankfully we do have them now in Scotland as a growing group, which are capable of eliciting the views and experiences of children in such a way as to help the right decisions to be made about their future. Just to give a very sort of clear example, but it's quite difficult to think about. Babies or toddlers who have been abused or neglected commonly adopt a strategy of not signalling their distress or their needs. So what you see is somebody who seems compliant or happy, but they've learned not to convey their inner distress because it's so frightening and terrifying when they do that. Now, you need really quite specialised skills to be able to get behind that and say, this is a child who really needs recovery. So the first point, what it looks like, it's skilled and it's attuned to the task. As to the independence, I think we would be we're not experts on advocacy per se across the board, and I appreciate there are important considerations about independence. I think the parallels with adult mental health and adult mental health tribunals are helpful in that regard, because there are quite often persons without capacity do need representation that is capable of being adequate to their needs for advocacy. And I think it's the same kind of new ground that we would need to break for infants and babies. And I think the primary criterion that we would want would be the availability of sufficient skills that would be attuned to the needs of the infants, and that the panel members, the decision makers, could have confidence in it being a robust and reliable process.
And is that what you mean by an infant safeguarder?
Yes. So, so that's about providing an extra safeguard for the infant, but that recognises how challenging that is within a complex system. That we're looking to shift a default. At the moment, the default, every discussion we have about the hearing system, what comes into mind about who it is involved is an adolescent who's speaking their mind. But we need to kind of change our way of thinking so that routinely we're sort of saying, okay, we don't really understand exactly what is going on in this child's life. We need more, and we need more independent sort of scrutiny and perspectives on this to be able to competently deliver what this child needs.
Thank you. Can I ask, Laura, how do you think that would interact with a non-instructed advocate or independent advocacy?
We think that it's got a complementary relationship. The two roles, I think, it's really important that they're held distinctly. They provide a different role in the hearing. A safeguarder makes decisions. The safeguarder makes recommendations around the best interests of the child, and as part of that, considers the child's view. In the situation of specialised non-instructed advocacy for babies and younger children and children with complex communication needs, it's a form of supported decision making. Their sole purpose is to represent is to ask questions about the rights of the child, and to make observations around the behaviour, which is a very specialised role and requires specific training, as has been said. And we don't think, and especially in the situation of infants and babies, there's any benefit to, in that context, reducing the number of adults in the room, because the recommendation is that they shouldn't be present at the hearing anyway. So the more protection around the children's rights, we think, the better, and that would be in line with the current guidance for the children's hearing system. I also think we need to be careful thinking about the role of having. We also need to be careful about losing that independence. So the responses to the call for views, some were recommending around having a guardian, as in the case, as is in the case in England and Wales and Northern Ireland, but a guardian can be a social worker, it can be a solicitor, it can be an individual that's been given permission by the court to represent the child, so there might not be that independence if that non-instructed advocacy role is lost. So I just think we need to make sure there's as much support around infants and babies as possible. And the last thing I want to say is, in terms of specialist training, the Scottish Government Expert Reference Group is currently developing what an advocacy qualification should look like in terms of skills and training, and it will really be rooted in what's already the kind of code of practice for the in the national practice model for the Children's Hearing Service. I also think we need to make sure we're not. We need to consider infants and young children, you know, separately and in their own right, but we also need to not over-pathologise them. I think there's been such amazing recent studies around the voice of babies. There was a conference by Starcatchers earlier on this year, sharing lots of evidence about how we can understand what a baby's views are and how they can exercise their rights. There was the Tiny Rights Detectives report by Together recently published, which was talking about how it's really important to make sure that wherever possible we can be involving babies in complaints mechanisms, for example. So I do think we really need to look ahead of the curve, and I think that's what you're saying in terms of the specialist training, and think about how can we be listening to what babies and young infants think. And the last point, if I may, is we need to make sure that we maintain the role of non-instructed advocates in order to uphold the public sector equality duty for children with disabilities, the Equality Act, of course, and looking ahead to future human rights developments in Scotland, the UN Convention on the Rights of Persons with Disabilities. So we definitely need to make sure those two roles complement one another.
Thank you, much appreciated. I know we're tight for time. Margaret Smith, did you have anything to add to what we've already heard?
No, I echoed the comment on needing a clear definition of independent advocacy and the need to for that understanding when it comes to non-instructed advocacy, because that is a model of independent advocacy that it can help with infants and those young children that maybe don't traditionally verbalise their views. That's a really important model of independent advocacy that needs understanding, clear definition and investment in.
Thank you. Thank you, Convener.
Thank you. Miles Briggs.
Thank you, Convener. Good morning to the panel. Thank you for joining us. I've got a couple of questions. I'll start now, and I've got some later on in this session, but it's specifically in relation to aftercare. And last week we heard a couple of views on that. And I know organisations like Who Cares Scotland has stated in their submissions that the aftercare provision in the bill could go even further, and I agree. And others have raised concerns around estimated costs with the committee. So I wanted to ask, how might these provisions be improved, and how do you think the Scottish Government can make sure that these are actually adequately resourced? I mentioned Who Cares Scotland, so I'll maybe start with yourself, Laura, and if anyone else wants to come in.
Thank you. Just finding my notes. So yeah, as I said earlier, we were so delighted to see the Calls and Jasmine's petition answered. As I think I said maybe earlier, we need to make sure that this provision is brought within the scope of the UNCRC and the rights are restated in this legislation, so that they could be subject to challenge under the UNCRC Act. And in terms of the implementation of aftercare, we do need to be thinking about how we can make sure that there's the eligibility isn't overly restricted, and I do think there's potentially some kind of there's some development in that respect as a result of the section in the bill on guidance in relation to care experience, where the guidance will be looking at the definition of care experience and how to make sure that that people who, for example, have received informal kinship care or have been in situations of adoption breakdown are able to access aftercare if they need it, or other supports. In terms of financial investment, the memorandum talks about the costs being steady state, so they don't look towards providing more funding to expand the capacity of aftercare, which is, appears to be an oversight. So I think we need to get some more assurances around the funding that will be required to make sure that aftercare can be provided. And I think local authorities will be particularly interested in that, given the kind of patchy provision that we've spoken about in terms of support across Scotland for care experienced people. You know, regardless of where you live or where you've been moved to, you need to be able to access aftercare, and there shouldn't be restrictions around, you know, you can't receive aftercare here because you were in care in this local authority when you were growing up. I think we need to move past those restrictive eligibility requirements.
Thank you for that. Anyone else want to come in on that point? Yourself, Matt.
Just we would highlight the particular transitions or particular points in people's lives who have experienced multiple adversities, which are particularly challenging. In this, we would highlight, in thinking about aftercare, there is a cliff edge that care experienced people too commonly face that we would want to put a name to, which is about when during pregnancy and parenthood, where all too often care experienced people rapidly find their relationship with care services flipped because they're subject to child protection activity, and with scant provision of therapeutic care. We certainly have insight into that from the research that we did on children who were removed into foster care, where vulnerable parents were quite often left without support while the processes were unfolding. So aftercare should be trying to address those particular pinch points which are so crucial in terms of having a compassionate, lifelong view of helping those who've been so vulnerable that they've required care of the state, that at this vulnerable point in their lives, that there isn't a cliff edge, that they're actually helped through that transition.
Thank you for that. And we've heard around removal of CSO, for example, as well, being one of those cliff edge points. Sorry, did Margaret want to come in on that as well? If not, hand back to yourself. Thanks for coming in.
Much. George Adam.
No.
Thank you, Convener. Good morning, everyone. I'd like to ask about the corporate parenting aspect of this as well, because it's come up quite a bit in the evidence. Corporate parenting was one of these things until I became a counsellor I'd never heard anything of, and then all of a sudden just became evangelical about it myself, the idea of how we go forward with it. But some of the organisations that have given us evidence, and especially Social Work Scotland, have argued that extending the corporate parenting duties to those who have experienced a small part of care in their life would give us some human rights issues. Now, my question would be, do you agree with that, or what do you think about that? And I, from my own perspective, understand why it's there, because anything could have happened in these young people's lives. They probably still need the support and care. But that's quite concerning if Social Work Scotland are saying that. So just who would like to go first and try and help me? Yep.
Yeah, I'm happy to talk about this. So it makes sense that the corporate parenting section would reflect the previous section around extending aftercare, and for corporate parents to be considering those young people that come off their orders before their 16th birthday. I think in terms of the concern around rights, I think the concern was really helpfully articulated by the Children's Commissioner when they gave evidence around needing to respect the privacy rights of a care experienced individual when presenting to services in order to access services by explaining that they're care experienced, and that there needs to be I think that part of the wording in the bill was around identifying, and I think that was the word that I think the Children's Commissioner were recommending be amended. Excuse me if I'm misrepresenting them, but that's to my recollection what the issue was around rights. I think having read the Social Work Scotland response, there was some terminology that horrified me around suggesting that, and it actually makes me feel quite emotional quoting the response just now, that you would be incentivising getting into care by creating more support. And I thought in 2025 we were past the stage where we were questioning the motives of care experienced people to access support. There was the term using care experience as a passport in order to access services. So for me, I think we really need to think about how we can address the rights concerns that the Children's Commissioner has about that part of the section, but looking more positively at this section, how much further could it go? We've heard from Matt about the experiences of care experienced parents, and we know from the promise around 2 out of 3 care experienced adults that we surveyed had a negative experience leaving care. 80% of care experienced adult participants that we spoke to wanted extra protection for their rights in law. Is there something more that we could be doing in this, in the regulations around this section, or the guidance around this section, for example, to encourage corporate parents to be providing more support to care experienced people throughout their lives? And obviously, we're looking at the financial memorandum even for the aftercare section. The resources behind this bill are quite limited, but we know that the corporate parents who engage with our training the most often and fully take up our offers of support are the ones who are most likely to have removed upper age limits and also widen their support for those with all types of care. So we've recommended that there's a duty for ministers to produce guidance that ensures regular renewal of corporate parenting training, particularly for senior leadership, because we've experienced that you need that buy-in in order to see really radical, amazing practice in supporting care experienced people throughout their lives.
Laura,
And I think that positive approach
I
is
get
really
that, because I got all of that when I was going through as a local councillor, and I bought into it. But some of the examples we were given, like, and I can okay, this is probably a perfect example, you know, because life ain't perfect. But one of the examples we got was a child that was in foster care and then maybe adopted by the time they were 5, you know, and then the local authority would end up having to have a duty to care, to support and care till they're 26. Now that's almost like a perfect scenario, you know, whereas we know in general in life ain't perfect, and the vast majority of young people that are going through the system won't be experiencing that. So how do you compare that to that example that we were given?
I think we need to remember that the corporate parenting duties are being alert to matters which may or may not adversely affect the well-being of care experienced people, promoting their interests, taking action to ensure they access opportunities, assessing the needs, which is the basis of providing support, and considering how the exercise of your functions could be improved in relation to care experienced people. I do think it's important for anybody that's been, in foster care, gone through adoption, to be on the radar of corporate parents, not in a kind of overstepping that state intervention way, but where you're presenting yourself to your local authority for support, particularly in the situation of adoption breakdown. We have such amazing, empowered members that talk about their experience of adoption breakdown and how they want to make sure that they are included in the eligibility requirements for more supports. And I think it's a really welcomed way forward to include them in this part of the bill.
Matt, you look keen.
Yes. No, I just want to echo that last point. I mean, I'm, Social Work Scotland's submission. I'm not a member of Social Work Scotland, and I don't speak for them. I am a social worker, and what I'm hearing from that is a concern about extra demand, and where there's concerns about the capacity of the system as it is. And so there was 2 points that came to my mind. One was related to what Laura's just said, but the first is that what we're considering here today is adapting and improving the whole children's hearing process. And our research shows that the way it is currently is very costly and wasteful of resource, including of the resource that local authority children's services have, because they're servicing a kind of a lengthy, drawn out legal process that requires a lot of what should be used for care and therapeutic support for administering a system. So there's more in this bill for Social Work Scotland's concerns, I think, than the noble intentions behind the aftercare and corporate parenting provisions. The second point I would make is that it's, to understand actually the stakes for children and young people when these decisions have been made. They were only in care for X number. For that decision to have been made in a child's life means that something was so seriously wrong. If you think about what needs to be the threshold for a child not to be with their birth family for any spell of time, this is a very serious life event, and it probably is a proxy for much more serious life events behind it. And the example that Laura gave is so powerful, because if you get adopted at the age of 5, the chances of that adoption breaking down have increased significantly compared to a child that's adopted at age 3 or a child that's adopted at age 1. And I think that I can think of many adoptive parents that would echo what Laura has said about the need to recognise the support needs for children who on the face of it aren't in the care system anymore, but they came from those experiences in the care system.
I like Laura's answer to it. I'm glad I used that example, because it looks perfectly reasonable when you read it on the piece of paper, and when you do look into the more detail in it. like you said in your answer, there's all kind of other concerns there as well. So, you know, it really kind of makes a difference. Thank you, Convener.
Paul McClellan.
Yes, thank you, Convener. Probably it's more on some general points, and I think, Laura, you mentioned this, and I'll probably come to yourself first of all in terms of this. I think Who Cares Scotland, the Promise and Children and Young People Commissioner commented in the drafting sections 1 and 2 on aftercare, which you've mentioned. I know in the register of foster carers in section 10, around about amending the Children Scotland Act 1995. Now, this is obviously pre-devolution UK legislation that falls out with the scope of the UNCRC, and you actually referred to that, Laura, in terms of this. I'm just wondering what your views are on that, on how these sections have been drafted and what might be done at stage 2 to bring this into scope. So I'll open with yourself, Laura, and then open it up beyond that. But you specifically mentioned that just, I think, a few minutes ago. So.
Yeah, my understanding is that the rights in the pre-devolution acts can be restated as freestanding rights in the sections of this bill. And I think when the government is committed to a maximalist approach of incorporating the UNCRC, that's what they should be doing to rectify the bill at stage 2. And I think, you know, in the past year, for example, we've supported over 900 under-16s with independent advocacy, helping to uphold around 5,500 individual rights. It's clear that this bill is a mechanism to ensure that that UNCRC rights would be upheld because there's stronger protections around the right to independent advocacy, but we still need to make sure that it falls within the scope of the UNCRC. I think it would be ludicrous not to make that amendment.
Anybody else wants to come in on that particular point? If there's nobody in that point, I'll probably come, Laura, I'll probably come back to yourself, because again, this is, we've seen submissions to the committee and calling for views about clarity and about proposals for guidance in relation to care experience, and was that effective enough? Again, the Promise Scotland and Children's Commissioner raised concern about the privacy of care experience people in relation to the proposal. I think obviously in your experience, and you mentioned the number of care experience people you've supported over that particular point, and it's very relevant to myself as well in terms of background I've got with some colleagues as well. So I think, just again, what your thoughts are on that in terms of care experience and how the proposals might be improved in that particular point.
Yeah, thank you. Yes, I think I kind of covered the privacy point earlier. Yeah. In terms of the guidance, we think they could be strengthened by being regulations. For us, guidance is too guiding and more of what we've already got.
So is that, just to clarify, do you think that should be on the face of the bill, or where do you think that should be?
On the face of the bill, there should be a duty to develop regulations that work to define care experience and that explore the concepts that are already, you know, in the bill around defining you know, stigma around care experience people. But I think it would be stronger if it was regulations as opposed to guidance. They would be more binding, and they would bring about more accountability. They would also be more easily updated, as I said earlier about the definition of care experience. We want to make sure that in looking at the definition, we're not reducing eligibility for supports and limiting that definition, and also being aware of, you know, evolutions in thinking around the definition of care experience. So we think that guidance is necessary, and we also think that it would be really useful to have a due regard duty on public bodies that can be consistently applied across local authorities, that promotes rights-based practice in those regulations. And again, we feel like what's really important when thinking about those regulations is that they are inclusive of all care types that were referenced in the promise in relation to care experience, including informal kinship care, for example. But yeah, I think there was a missed opportunity in terms of encouraging a promotion of rights-based practice. We need to make sure that we're not having policy areas in silos where you've got things about the promise and care experience on one hand and things about equality and rights on the other hand. We really need to streamline care experience across these areas.
Okay, Laura, thanks for that. Margaret, can I come to yourself? Because I mean, what we've heard on previous committee sessions as well is talking about obviously the role of advocacy, now whether that's independent or not. But I think one of the key things that you've probably seen people in the sector themselves who are care experienced is then going on to be advocates for people who are entering or coming out of the system. So I don't know what your thoughts are on that in terms of that particular point, because I think that's very relevant. And again, like George, I was a councillor for 15 years, so seeing that role close up as well in terms of that. So I just wondered what your thoughts were on terms of that.
In terms of young people then becoming independent advocates?
Yeah, I suppose, yeah, more about and the care experience and how that then follows through, because I think there's not be any better advocates, I think, or people assisting that have actually been through the systems themselves.
Yeah, I think that evidence the need and the benefit of independent advocacy, the fact that so many care experienced young people then go on to help and deliver advocacy themselves. I think that does evidence the need for it and the benefit that independent advocacy can have in a person's life.
Okay, Margaret, thank you for that. I don't know if anybody else wants to come in on that particular point. I'm conscious of the time, convener.
Thank you very much.
Okay, thank you very much.
Thank you. John Mason.
Thanks, Convener, and kind of onto the area of profit that might be made through residential services. I realise, Mr Hogg and Mr Birmingham, you haven't said anything for a while. Do either of you have views on that subject? Are there profits being made, excessive profits? If you don't have anything to say, that's all right.
I can express a view. It's not something we've considered at length within Children's Hearing Scotland because it's out with our purview. But I suppose having managed residential services in the past and had quite a lot of exposure to the commissioning model in relation to profits, my strong view is that money generated through the care system for looking after some of our most vulnerable children and young people should be reinvested into the care system. One of the particular challenges I had in a previous role was around the levels of remuneration for residential workers, having to compete, for example, with night workers working in residential homes, which I managed, having to compete with Tesco's in terms of wages. And my takeaway from that was actually that profits need to be reinvested into the workforce and reinvested into supporting services that support the young people, but that's not a corporate view of Children's Hearing Scotland, that's just from my professional experience.
Okay, fair enough. Mr Hogg?
I can't really add anything to that, but I was struck by some of the evidence last week, which was pointing out that you need to be clear on what you define as profit.
Yes.
There's a lot of the care facilities and care options are operated by charitable organisations, and so they may, on the face of it, be making a profit, but that will be reinvested, as Stephen says, for the good of children and young people. So there just needs to be some care around what we define as profit, I would say.
Okay. Well, Mr Ford, and Ms Pasternak, you said more about profit, so I was going to come to you next. But on that point, I mean, that is a good point as the definition of profit, because the language in the bill seems very, very vague. In section 8, it says, regulations may specify how the level of profit is to be determined. So, I mean, goodness knows, I mean, accountants have been arguing over what profit is for hundreds of years, so the idea that the Scottish Government's going to come up with an idea in 10 minutes seems unlikely. But can either of you give me your thoughts about profit? Any profit, or eliminate it, or excessive profit, or what, Mr Ford?
I think the care of our most vulnerable children should be something that we see as a right, and the children are entitled to the highest standard of care. I'll speak as an individual citizen who's worked in care of children all my career, but the first 19 years I worked in residential childcare, and I was very conscious that it was a completely Cinderella service. It didn't have the investment it needed to provide the quality of care that those children deserved. And the thought of any resource being skimmed off to provide profit, to me, is unpalatable. I think it's a bigger issue, which is a about what we would regard as good enough for our own children, and a framework of rights which would then determine the obligations on public bodies to provide the adequate care, and if they contracted others to do so, that's on the basis of it providing the best possible standard of care rather than...
So you've twice said care. I mean, that's the important point, isn't it? The quality of care.
Yes.
Do we have any evidence that the private sector provides better care or worse care?
We really don't have good evidence across the board about outcomes for children in care. With another hat on, I would say we need more research on that. But we do know some of the things that provide for success, and that involves children getting access to stable, committed care as early as they can. So that means that children aren't languishing in residential care homes or temporary foster care for many years.
Okay. Ms Pasternak, I mean, when I go to the optician, get my eyes looked after, the optician makes a profit. So why shouldn't the children's care providers make a profit?
I think that's a very good question. I think what we need to be thinking about is what we mean by profit, like you said earlier. And I think if we look to what the Welsh Government's done, they're making sure that money is saved from shareholders' profit, and that money will be reinvested into children's welfare. And I think we need to make sure that the highly skilled professionals that are required to deliver children's care are paid accordingly, in line with cost of living. We need to make sure that there isn't excess profit being made and then invested into the shareholders' pockets, as opposed to reinvested back into the provision of children's care.
So you'd be comfortable if a bit of a surplus was made and then it was kind of improved the buildings?
Well, that's what is happening. Well, that's what's been kind of proposed and approved in Wales. That's part of the move that they've taken there, and that's I think why we need to have a stronger definition of profit making in the regulations, and we need to make sure that the regulations clarify that any surpluses must be reinvested back into care services. I think the other thing we need to be really mindful of is making sure that there's continuity and stability for children that are currently in for-profit placements, and if there's any kind of transition, that they're fully supported there. And when you mentioned previously about I can't really remember your wording, but it was about doing something in 10 minutes. I think it's really important that we need to make sure we're consulting with obviously the sector, but also children and young people in those settings to learn a bit more about the quality of care that they're receiving, and to include them in this process. And
so would the fear be that some organisations or businesses would kind of just close down and walk away if the regulations were too tight?
Yeah. I think we need to make sure that our roadmap is clearly set out, that sets out how we're going to get from A to B, and make sure that there's stability for the children and young people that are at the heart of it all. Okay.
Ms Smith, did you want to come in on this point? No, not at all. Okay, that's fine. The next side of this is fostering, the idea that the agencies should be charities, which is slightly different from saying just they don't make profits, although it's kind of similar space. Mr Ford, back to you. Any thoughts about that? Is it right to treat them differently from the...
Our thoughts are about supporting the best possible standard of foster care, and in making it much more available across the country as a provision that equally could enable foster carers to become adoptive carers. So it's more about how is it we engage with people who want children in their lives. The means of doing that is not something that we would want to.
You're kind of more relaxed about that, how it's done?
Yes.
Yeah, okay. And then finally, if I may, on the financial memorandum as a whole, once it settles down, it looks like we're talking about 20 to 23 million per year. That's about 29-30, building up to that. Any of you, I'd be interested in your thoughts. I mean, about a third of that would be extension of aftercare, a third advocacy, and a third the children's hearing system, which I think means primarily paying the chairs more. Are these figures realistic? Are they too low? Or is any part of them too low, would you say? Mr. Birmingham.
Yeah, I mean, I can only really comment on the aspects in relation to the children's hearing system. We spent a couple of years working with ASETS, an external accountancy company, and the Scottish Government in terms of modelling our costs, and we're pretty confident that the costs within the financial memo reflect the costs of actually running the service. So we're pretty comfortable with what's in there from a Children's Hearing Scotland perspective.
Which is primarily paying the chairs, but not paying the other members.
Oh, correct.
So if we played around with that, then that would obviously affect the figures then.
Yeah.
Yeah. Okay. Mr. Hogg, were you on that point?
Not specifically on that point, but just generally in relation to the financial memorandum, in relation to the elements that relate to SCRA, the only comment I would make is that we costed that on the basis of what we had believed would be in the bill, and what is in the bill is slightly different. So particularly the provision around the post-referral meeting with the reporter, it does within the bill have a kind of more significant status than we had costed. So that might be a slight underestimate, but it's not going to affect the figures too much. And more generally, just on financial memorandums, that they are kind of estimates, they're best guesses. And when you are looking at provision of funding for local authorities, you always have to divide that by 32 and then apportion it according to the size of the local authority. So it kind of breaks down the figures. It's sometimes quite a good way of analysing it.
I mean, I think the Finance Committee is hoping it's the estimates rather than the guesses, but anyway. Any of the other three of you want to say anything about the financial memorandum before I finish?
Just one point that's potentially of comfort, which is that our research looked at the cost of child progressing through the hearing system as is and compared it to similar children in England, found it was twice as expensive here, entirely as a function of the delays and drift. If we tackle the delays and drift, we will reduce costs.
Okay, well, that's good to know. Yes, Ms Parsonage.
Yeah, I think that's a really fair point. And when considering the financial memorandum, considering the bill as a whole in perspective, and the measures that I see as a measure of early intervention, such as providing advocacy, will really help reduce the pressure and the strain on public services in the long term. And the money report from the Promise exemplifies that. We also know there's recent research from the Henry Smith, the Henry Smith and Social Finance, published around for every £1 spent on advocacy, £12 is saved. And I think that's...
We do get a lot of people telling us if we just give them £1, they'll save us a lot of money. Thanks.
Yeah.
Ms Smith, did you have anything to add?
The approaches in terms of independent advocacy, just to ensure that it's adequate and sustainably resourced, and learning from the children's hearings legislation where advocacy under section 122 is a legal right for children and young people, that the initial figure of 10% of uptake of children and young people has been exceeded in terms of the need and the demand from young people themselves. So I think it's just important to bear that in mind, that they are estimates, but when it comes to the uptake from children and young people themselves for independent advocacy, it just needs to be considered in terms of the financial landscape.
So do you think the advocacy figure might be a bit on the low side?
I don't think I'm best placed to comment on the actual figure itself. As I say, just to ensure that it's adequately resourced, I suppose.
Okay, that's fine. We'll chase up other people
on
that point. Thanks, Convener.
Did you want to come in, Ms Passon?
On the low side, we think that it underestimates the care experience population that should have access to lifelong independent advocacy. It doesn't include informal kinship care, for example, and it underestimates the uptake, as Margaret was saying. So for children's hearings, there's 20% uptake, but it's funded at 10%, and there's no uplift for children's hearings advocacy estimated, and we think for the kind of for lifelong advocacy, it's proposed to be funded at 5 to 10% uptake, but we think we should at least match Children's Hearings Advocacy. Scottish Independence Advocacy Alliance recommends 50% uptake. We think that the offer should come from an advocacy worker, because we know that when the role of an advocate is explained by an advocacy worker to someone that's needing advocacy, from our experience, there's a 98% uptake. I'm not suggesting that there's enough money to fund 98% uptake. I would love it if there was, but I do think that the current estimates are an underestimate.
Okay, thank you. We're going to go back to Miles Briggs now. Miles.
Thank you, Convener. I wanted to raise a question in relation to the Register of Foster Carers. And I asked this last week as well to the panel, because I think there has been some welcome comment in the call of views around and supportive of a register, but I just wondered how the panel thinks that will work in practice, given again this is going to be set out in regulations at a later date, and what your assessment of the proposals for this register will have on the bill and help to improve the legislation. I wonder if anyone has a view on that. I know we've got others in the next panel who will.
I can say it very quickly.
Sure.
We think the register should also record complaints and concerns made about a foster carer by a child. Obviously this information would be held privately, and that would help concerning patterns of behaviour being identified, and the reason we're suggesting that is because of the evidence submitted to the abuse inquiry, and also we think, similar to what I've said previously, that this section needs to be within the scope of the UNCRC.
Great. Nice and short and sweet. There we go.
Okay, thank you. We go to Jackie Dunbar.
Thank you. Thank you, Convener. I'll be short and sweet as well and concise. I'm going to go back, if you don't mind, to some of the comments that you made. I'm going to go to Mr Hogg and Mr Birmingham. In your opening question, Convener, regarding children's hearings and your views on the single member panels. Mr Hogg, you said you were broadly supportive, but you had some reservations. Could you maybe go into a bit more detail about what reservations you have and what further exploration you feel is necessary?
Yeah, I'm happy to do that. So I think the first thing to say is that the single panel member proposal is something that we haven't tested. So I guess we're in the dark as to what benefits it will bring. So we have to try and logically assess what we think those benefits might bring. There is some hints within the policy memorandum around what are the perceived benefits, and we can see ourselves that there are potentially benefits in terms of saving capacity, in terms of panel member capacity. We don't think that alone should be a good reason for making that change, but we do see the impact of that, and Stephen undoubtedly will probably say more about that, and it is a very real issue around that capacity. We can see that in some regards having one person making the decision could bring a simplicity to certain decisions.
Can you expand on what you feel that could be? You know, what I'm thinking what level, but that's not the right word I'm trying to use. But you know, when is it okay? When do you feel that it's appropriate for a single member? Up to what level?
So yeah, that's quite difficult to define. But I think what you're asking is around what you might view as a procedural decision and what might be something that would be more substantive.
Yeah.
So more procedural decisions would be ones that would, on the face of it, appear to be relatively straightforward. They would be matters that we would currently undertake in a pre-hearing panel, such as whether you should excuse the attendance of somebody coming to a hearing. But there are other decisions that can be made by pre-hearing panels that might, on the face of it, be fairly straightforward, but aren't always. So questions around deeming someone to be a relevant person or undeeming someone to be a relevant person can be quite complex. And and some of those decisions might be better suited to having three minds, three decision makers rather than one. The area that I think we've identified the greatest question around in our submission to the call for views is around the proposal that a single panel member can make decisions around issuing an interim compulsory supervision order. And those are some of the most challenging and impactful decisions that a hearing can make. I think it was mentioned actually earlier on by one of my colleagues on the panel today. So we think that that's something that we would need to look at more carefully. All of this would benefit from more considered and detailed thought and development around the proposal, and testing and evaluation of that testing. And we think that would be a way forward. We think that there is also some implications that there might be in relation to the overall perception of decision making within hearings. The policy memorandum of the government references that that the optimal decision making forum would be three panel members for substantive decisions. So it may then open the question, well, why is that decision suitable for only one person to do? And it's not necessarily about the competence of the decision maker. It's more about the as the government points out, the collective thoughts of three people that collectively reach a view about a decision. So, so whilst we can see the benefits that this may bring, we would like to see it properly tested and evaluated to discover where that line that you described might lie.
Yeah, okay, thank you. Mr Birmingham, do you have a...
Yeah, thanks for the question, Jackie, and it's one that we've considered carefully. I mean, I suppose there's a number of aspects to this in terms of that single panel decision-making model that we're broadly supportive of. The key one, I suppose, is about removing the procedural legal burden on three-person panels, because what's happened over the last 20 years is that legislation's been layered and layered and layered and layered. So the technical competencies required in order to make these legally binding decisions has become more and more difficult, and that's why we want a legally competent chair that can kind of digest that information. As Alistair alluded to, the substantive decisions in terms of making compulsory supervision orders would still lie with a three-person panel. But what is described in the policy memorandum is in relation to some of the more procedural aspects. So what is at the moment the pre-hearing panel, which is the relevant person status, decisions about appointing safeguarders, excusal attendance, whether people can attend by electronic means, and that type of thing, and also potentially looking at urgent interim compulsory supervision orders, for example, moving a child to a place of safety. We think it's a necessary thing in terms of, as we specialise, that we have chairs that are qualified and competent to take some of these more procedural decisions. One of the challenges we have with our current model, for example, is around just the increase in legislation, and each bit of legislation introduces new complexities. And when we, for example, with the Care and Justice Act, require our panel members to undertake mandatory training on a purely voluntary basis, that's quite a big ask of 2,200 volunteers to give up their time. And if we really want to shrink and specialise and develop the expertise within the hearing system, we need to have people who have the time and the resources to develop those skills. So and there's also, I suppose, in terms of the decisions, the procedural decisions being taken, there is also safeguards in place to, for example, the right to legal representation, and also the national convener maintains the option to default to a three-person panel if the decision, we need practice guidance to support that, requires that. But these are really around the kind of procedural things, and it means that those panel members from the community that give up their time to support children make decisions in their best interest can actually focus their attention on doing that and not some of the kind of legal technicalities that have come into the system as it's evolved and developed over the years.
Okay, thank you. And you've kind of already answered my second question, was about remuneration of the chairs. You said previously in the convener's question that you're supportive of the enhanced role of the chair and to have one chair throughout that one process.
Yeah.
So I guess, and I'm going to ask Mr Ford, because you spoke about it as well, in regards to specialist panellists, are you supportive of them, and do you think that they should be paid or remunerated, I can't say that word today, for travel, etc. Just your views on that.
Yeah, and I think what will happen as well, in terms of the new enhanced role of the chair, that will bring in a level of specialism, because the skills and the competencies and the qualities that will be required of these positions, you know, they need to understand the legal competency of the children's hearing system, they need to understand children's rights, they need to have experience of managing conflict and difficult situations. We are supportive of the specialist panel members, although we...
Every time or just when you...
No, less than 5% of the time, so used sparingly where required. At the moment, there's a number of provisions that exist within the children's hearing system where you can bring specialists in, so a panel can decide to appoint an independent report writer who has an area of expertise, for example, in early years, to do a report. There's also the option for safeguarders. So there's a number of options at our disposal at the moment. But there might be certain cases, as we expand the remit of the children's hearing system, where we will need to bring in particular specialists. Now, they will be first and foremost panel members, but they would be expected to have specialisms. For example, if in an area like additional support needs or criminal exploitation of children, if there's a level of insight that that three-person panel needs in order to take that decision, we want the option to bring in a specialist, but we anticipate that would be used less than 5% of the time. And it's a way it helps future-proof the hearing system as we continue to shrink and specialise.
Okay, thank you. Mr Ford, do you have anything to add from your comments before?
Well, it's really just to reinforce in the instance of babies and infants. First, a general observation, which that every procedural or other kind of sort of step in the way matters in the life of an infant or a baby. So the provision of skilled, legally competent chairs that are consistent means is as important as the number that make up those who make the decision. And secondly, that if there are decisions about that rest on understanding what's best for the child in the context of their experiences and their needs, that there does need to be adequate specialist input to the panel.
Yeah, and in regards to, you said earlier that specialist panelists would be good for baby and toddlers. Do you mean every time, or like what Mr Birmingham said, just as and when needed, but it's important to have that oversight? We're
calling for legislation to allow for a trial of an approach that provides this for a safe baby approach to managing those cases through as part of this legislation, to determine then what a framework would be for delivering consistently a high standard for all babies and infants.
Okay. Convener, if nobody else wants to come in, I will go back to you.
Willie Rennie.
Yes, good morning. A lot of people are pretty underwhelmed by this bill. They think it's an indication that the promise is not going to be kept, because some of the original measures that were floated as possible inclusion within the bill are not in the bill. And some people believe that means that we're not going to meet the promise by the target deadline. I'm interested in whether you think that's the case. Alistair, do you want to kick off?
So, I mean, overall, meeting the promise is a pretty huge commitment and a pretty huge task, and we're kind of a little bit over halfway towards the target of reaching that. This is most definitely a step in the right direction. There are a lot of different elements of the bill, a lot of questions being asked about various sections of the bill, and obviously the part I'm most focused on is the hearings redesign part of it. What I would say, to some extent I understand the use of the word underwhelm, but for myself, so integrated into the system and so involved in the system, I do see the proposals around the hearings redesign as pretty significant. So I would say they are pretty transformational changes. If you look at the kind of two main changes that are made, the proposal to remunerate chairs and what may flow from that, that's a pretty significant development. And the changes to the grounds process, albeit that there's a lot of detail around that, is the other major area that we identified as needing some kind of improvement. So what's in the bill around the hearings redesign we think is pretty significant change. What's in other sections of the bill we can see also brings quite significant change, but does it fully meet the promise? Of course, no, it doesn't. And undoubtedly, you heard last week from people who said there would require to be further provisions coming in the future. But I think it's a progressive step towards meeting the promise.
Mr. Ford.
I would start by saying that meeting the promise, we've approached our submission through the lens of babies and infants. And we see that as actually fundamental to the whole system and to addressing the issues that the promise uncovered. Because babies and infants in the hearing system become the older children and adolescents and young adults who require the support that we're talking about in terms of aftercare, and they help to achieve their rights that being care experienced has compromised. And by getting it right in the early years, we will help keep the promise for older children, because what we found out 20 years ago, that the persistent young offenders that we were so concerned about at that time were actually children who'd first been known to the system under 5. What we would say is that if the amendments that we're proposing were to be brought in, that we'd go a long way to meeting the promise for babies and infants. So I think there is an opportunity. It's about strengthening the provisions around the authoritative chair, strengthening the provisions around advocacy so that children, babies and infants are independently represented. It's about strengthening the provision for specialist panel members. And it's about being bold enough to test a completely new approach for babies and infants within the hearing system. So we see a huge opportunity here.
Okay, I'm going to come back to Laura in a second because I want to ask you an additional one. And Mr. Birmingham, yeah. What do you think?
I mean, I think in terms of the redesign of the children's hearing system, I do think it meets the aspirations of the promise in terms of the shrink and specialise. So that's, I suppose, the bit within my purview. In terms of the wider meeting the promise by 2030, I think what we need to acknowledge is that the children's hearing system is only one point in time for the child in terms of their journey. And the orders are reliant on services at a local authority level or commissioned through a local authority in order to implement those orders. So I think it does meet the promise in terms of the children's hearing system redesign, but I think that the really challenging bit of the promise will be about those children's services and what that means for the child in their everyday life at a local level. That would be my view.
And Ms Smith?
In terms of... Oh, apologies.
No, it's all right. No, it's okay now. It's fine. Yep.
Okay now. So I'll just repeat, it is significant in terms of providing independent advocacy for that lifelong independent advocacy for care experience. It's something that is a positive and will help meet the promise. I think it demonstrates the listening to the views of the children and young people. Earlier there was a comment about young people then becoming independent advocacy workers themselves, and I think it is a significant step to invest in independent advocacy and listen to what children, care experienced children themselves are wanting and needed when it comes to shaping their future and shaping services. So we do think this is a significant step.
Okay. Laura, I was struck by what you said earlier, where that you thought there may be circumstances where young people were encouraged to stay in crisis in order to access, in this case, independent advocacy. That's what you feared might happen.
No, that's what Social Work Scotland fear. That is not my position.
Right. So do you not think that's happening?
Absolutely not.
Okay. I mean, I've heard instances where I have heard it's happening, where young people have been encouraged to say they continue to be in crisis in order to access the level of support that they need. Otherwise, they'll be back in crisis again, is the view. And I've heard that from others. But you're saying that's not happening?
No, our experiences of young people not being sufficiently informed enough about their rights, and that's obviously where advocacy comes in, and being encouraged to, for example, come off their orders before their 16th birthday to then save 10 years funding and aftercare. So our experience is not that. And I think to suggest in this day and age that you would... I think you just need to listen to the experiences from the Independent Care Review to understand that there isn't an incentive to go into care. I actually don't even understand why I'm having to answer.
No, I'm not advocating that this should be the case. What I'm saying is that because services are so underfunded and staff are so stretched, that the young people have to say they continue to be in crisis, or otherwise they'll get nothing. That's my point.
Yeah, I understand your point. I wouldn't say it's something that...
You've not come across that?
No, absolutely not. It's the opposite. Our members are struggling to access support. They're experiencing cliff edges of support right, left and centre, be that via eligibility, be that via decisions that are made because of stretched resources, and be that because of discretion that's being applied.
I think we're saying the same thing.
I think we're on the same page.
Yeah. So my concern is that if we are improving the offer, including independent advocacy, is there not the danger that we're going to end up in the same place again, because the overall provision isn't going to be sufficient and people are going to have to say they're in crisis in order even to get a basic level of support? Do you not fear that that might be the case?
No.
Does that make sense?
No, advocacy is a point of early intervention. The whole point of advocacy is to be able to be informed about your rights, to ensure that you are able to claim them and that they're not breached.
But if the services are so stretched that it's only available for those who are in the most extreme of circumstances, is there not the case where we're potentially promising something as an early intervention and it just becomes a crisis provision?
I think we're talking about two separate things. I think we state very clearly in our response, we echo many of the concerns from Social Work Scotland, for example, from some of the concerns that are highlighted in the Promise Oversight Board's reports around that there needs to be more investment in family support and to addressing the social work staffing recruitment crisis, and that is valid and that stands, but that for me that's a completely separate issue to ensuring that care experienced people's rights are being strengthened by this bill. And I think I've heard a few times at committee and in responses varying tests that this bill should go through. So for example, the real test of this bill is whether or not it's going to make it easier or harder for the workforce to deliver. The real test for this bill is whether or not it whether or not it keeps the promise in its entirety. For me, the real test of this bill is it going to make care experienced people's lives better, and is it going to ensure their rights are upheld? And the answer should be yes, because that's what's been proposed in the bill in various sections. You know, children's hearings, advocacy, aftercare. To kind of link back to your previous question around kind of underwhelm, I think given that the implementation of the promise has obviously been challenging, the pace of change hasn't been as hoped, the system remains with, you know, it doesn't remain without problem, and that's why I think it's really important to take action and advocacy to make sure that there's a kind of individual commitment to support the promise being kept for each care experienced individual. I also think that we need to think about the fact that the promise was passed 5 years ago, and there's an expectation that things would be better. Many children have aged out of advocacy services, and would have had that expectation that they would have had more access to their rights earlier. We need to be looking at, you know, the system and investing in the resources required to implement this bill, but then also what the next steps are for the next government, and that's kind of why I think we need to build in more accountability measures in the bill to really put that a marker down for the next government.
Okay, thank you, Convener.
Thanks.
Thank you. Bill Kidd.
Yeah, 22, please. Thank you. Just my age. Thank you. Aye, somebody could laugh. Thank you. Just to ask you a couple of questions here about the bill's proposals that integration joint boards will join with local authorities and health boards on the list of bodies to lead children's services planning. Now, this is in the bill here, and it's generally suggested that further guidance would be required for this to take place. And in fact, Matt, NSPCC Scotland have said that the rationale for the extending this existing situation for responsibilities to integration joint boards isn't very clear. Do you have concerns there?
Not so much concerns as, you know, the heart of the matter from our point of view is how well we're serving children in a timely way. And that does involve cooperation of public bodies in making integrated, coherent strategic plans to deliver that. We're not convinced that a sort of a redesign of the public service system is what is really at stake here. I think the issues about the children's hearing system process and the associated practice issues, i.e. what happens in local authority, are the most significant things for this bill. If those integration measures assisted in rationalising all that, will all to the good, but I'm not convinced. You know, I in my own career, speaking personally, in my own career, I worked as a head of children's services in an integrated health and social care partnership that was then unwound because it didn't achieve its aspirations, and it's been since reformulated after I left it. But you know, efforts to integrate planning structures are not new. In Scotland post-devolution, and as I say, our concern really is in how is this system going to work better in a more timely way for children, especially when they most need it, which is when they're youngest. And if the proposals around integration of the planning bodies will assist that, well, that is all to the good.
Okay, thank you. I think Stephen and Alistair both look interested in this. I don't know why. Maybe they're involved. Stephen, do you get anything to say?
I don't have a view on that, Bill.
You don't. Sorry, beg your pardon. And Alistair?
No particular view. Just to say that obviously children's services planning is much wider than simply the children's hearing system, so it's much bigger than that. But it's not an area that I would feel able to comment on.
Right, no problem at all. I don't know if Laura, you.
We welcome those proposed changes, but from the perspective of the fact that integrated joint boards are corporate parents, so we feel like it makes sense for them to have that role to play when promoting the health and wellbeing of care experienced people in their area.
Well, thank you. And Margaret, in terms of advocacy, do you think they would be beneficial? Integration joint boards?
I suppose when looking at the commissioning of independent advocacy, consideration with previous models, so if we take children's hearings, independent advocacy, which 10 providers are responsible for that, and the funding, the management of that comes from the Scottish Government. So I think that is to be considered, or if it's the responsibility of the Health Board to then commission independent advocacy services. I think that we need to look at what is working, what has worked in the past and what's worked previously. There are independent advocacy organisations across the country, some of which are commissioned by the health boards, and so the bill proposes to complement those existing independent advocacy services. So that is something that would need to be considered when it comes to the commissioning and administration of the independent advocacy in relation to this bill.
Well, thank you very much. It does sound, from what's been said, as if people aren't terrified of the idea of IGBs, but they do believe that more work needs to be done if they are going to be introduced anyway. So I think thank you very much. Thank you.
Thank you very much. We move to Ross Greer.
Convener, I was almost going to say good afternoon. It feels like that. We're still in the morning. Good morning, all. I just want to tease a little bit, because there's been quite a lot of consensus this morning, but Alistair, in your written submission, there were definitely some points of difference, so particularly where I think a lot of other organisations have welcomed the enhanced role for the reporter. You flagged up issues around power imbalance in the written submission. It touched on that a little bit already this morning, but I was wondering if you could maybe just draw out some of those concerns for us.
Yeah, thank you. So, yeah, so broadly we are in favour of having the option of a meeting with the reporter. We can see a lot of benefits from that. It is something that can happen now. It does sometimes happen now, but it is something that we would be happy to expand upon, and we can see the motivation and the intention behind that. We also have come on a little bit of a journey in terms of whether that should be something that should be placed in statute. And I think that on balance, we think it probably is a good thing to have it in statute for a number of reasons, not least of which is that it gives a legal justification to have such a meeting. Where we have some concerns is around what flows from that meeting, what are the expectations around that meeting. We, I think, had imagined that meeting would be something quite informal, something that would be within the discretion of the reporter within our role, that we would assess the situations and the families where such engagement would be helpful and appropriate and sometimes safe. But what the legislation or what the bill proposes is to be fairly detailed around what that meeting should discuss. And
so
then
quite formal, not the softer approach that you're indicating.
The fact that it sort of stipulates the things to be discussed, and also it makes it a duty on the reporter, which can only be dispensed with if it's felt to be inappropriate or ineffective. So we would need to be clear on what comes under that definition. And also there are, I suppose our concerns lie in some of potential consequences that may flow from what takes place in that meeting, or from the fact that the meeting doesn't take place at all, because a family would not be required to engage with such a meeting. It would be entirely voluntary. But the requirement that the reporter then has to prepare a report, which would be for either the hearing or the court, whichever route the reporter chooses to go in relation to the grounds, does then create that sense of formality around the meeting. So we believe that we'd have to be very careful around managing perceptions of what takes place in that meeting. That's where we get into those areas of concern around potential perception of a conflict of interest. The children's reporter is the independent officer who has initiated the process. We believe that the child requires compulsory measures of supervision. We have framed grounds which we believe are evidenced and are required. So we have a vested interest in establishing those grounds. So we want to make sure that there is no sense of pressure on the family, and particularly on the child, to feel like they have to give a certain response to the grounds. We were a little bit concerned that the report might then be used in the hearing to record whether the child has understood the grounds or is capable of understanding the grounds. And we think that rather than that being determinative for the hearing, it should simply be something that could be taken into account by the hearing. And because of that sense that the meeting feels more formal, we believe that some kind of record would need to be kept, and also that people's rights would need to be protected in such a meeting. So you then go into consideration of advocacy provision and legal representation as well, and giving people the option to do that. So the concept is something that we are in favour of, but we think that it could be developed a bit more to kind of meet some of those concerns that I've outlined.
Thanks, George. That's really helpful. And specifically on the report, because I think that points to the wider question that you're indicating of there's quite a lot of detail about how the meeting should take place. There's then more ambiguity about what impact it has on the rest of the process. Would it be helpful for the legislation to go into further detail about what the intention, what the purpose of the report is, what it can and cannot then be used for? Because some of what you're saying makes me think, right, we need to think about amendments that really clarify what the point of this was and what the product is. There's a tension between that and the point around the preference for an informal approach, because the more we detail in legislation, the harder it is to take an informal approach here.
Yeah. So to answer your question, I think there would be benefit in looking at that. I think it would be helpful to understand what is envisaged to be contained within the report. You know, what level of detail would be expected. We at the moment think that the best way is for such a report to be very factual and quite high level, to avoid some of those issues that I've highlighted, and what is its purpose, what is to be used for. I think that would be helpful to clarify.
Thanks very much. That's all from me for now, Convener.
Thank you. And finally, we'll go to Ros McCall.
Thank you, Convener, and hello everyone. My question is sort of a follow-on from both Mr Kidd and Mr Rennie, because their questions were very much around the situation as it stands, utilising the IJB, workforce, concerns with social work. And what was, for me, the best way of us getting to achieve the promise that we all know we're heading towards is the implementation around this, especially when it comes to workforce planning and capacity. We know that IJBs are struggling all across the country. We know that a lot of them are borderline broke. So has the bill providing the right avenue to achieve the implementation and workforce planning that we're looking for? Is there adequate funding for that? And given the different sections that you're in, can you give us any unintended consequences that you think of the bill as it stands that you would see glaringly, obviously, that is there? So those kind of three questions all rolled into one. Is it the correct avenue as far as workforce planning and funding, and any unintended consequences on the bill as it stands? And basically everybody. So if I could start with Margaret Smith, please, since you're not in the room, I'll start with you first.
Yeah, so I suppose I can speak from an independent advocacy perspective in terms of the workforce development. You know, we've spoken before about the demand for advocacy exceed the current capacity, and so in some of the funding that is set aside for independent advocacy, some of that does need to go into the workforce development in terms of training. Laura had mentioned before about the expert reference group developing a qualification for independent advocacy. And certainly all of that needs to be considered in being able to skill the workforce, in terms of also the comments and the need to provide specialist support for babies and infants, the need to invest in non-structured advocacy, and the definition and clarity around that, to be able to provide that model of independent advocacy to ensure that that the offer of independent advocacy is available and accessible for all.
So do you think there's adequate funding provision to achieve that?
I know I was asked this earlier, and so I would echo what Laura had said in terms of more funding would be required, especially from learning from the Children's Hearings Independent Advocacy Scheme, where the 10% has been doubled, and we're heading toward triples at this stage in terms of the need for independent advocacy.
And is there any sort of unintended consequence that you can see from the bill as it stands at all?
Again, from an independent advocacy point of view, any consequences?
If not, that's okay.
I don't want just in terms of not going to repeat myself continuously. If the model and the definition of independent advocacy is followed, and that offer and properly resourced and sustained resource, then to ensure that the offer of independent advocacy is actually realistic for care experienced children from birth and onwards across Scotland.
Okay, that's helpful. Thank you. Mr. Birmingham, can I bring you in first, and we'll just work our way along the line. Is there anything that you think is it the right avenue, right funding, and is there any unintended consequences that you can see?
Yeah, thanks, Ros. In terms of the workforce, I don't have a particular view in relation to that. I don't have a particular remit in terms of that. I think one of the potential unintended consequences that we have some concerns around is around the change of attendance in relation to children's hearings. So moving from an obligation to a presumption. And what we really want to caution against is that the child and the child's views aren't at the centre of their hearing. We don't want to essentially sleepwalk into a position where children aren't routinely attending their hearings, because we know from feedback from panel members and children that actually when they attend and participate and are supported to participate, it leads to much better decision making and better outcomes for the child. So I suppose at that point, in terms of workforce, making sure that our colleagues across social work departments and also the advocacy providers are really empowered and supported and resourced to make sure that that child's view is fed into the hearing system, and we don't end up in a place where children aren't attending. That would be the only unintended consequence that I had identified.
Thank you very much. Ms Pasternak.
I think in terms of workforce planning, obviously that's not our area of expertise, but I just reiterate what we have kind of on the face of our response, that there needs to be sufficient investment in services to ensure that the bill can be implemented effectively. And I think we do need to test some of the assumptions in the financial modelling and get some reassurances at stage 2. I think also in terms of when the bill's passed, the reason we've recommended having a measure around post-legislative scrutiny is so that we can be evaluating, obviously, the implementation and analysing the need that's being presented and increase targets accordingly as we head towards 2030. In terms of unintended consequences, I'd echo what Margaret's already said about needing to ensure that we get the word independence in there to make sure that the definition of independent advocacy is really clear and well understood, and that is separate to service provision. And I think another unintended consequence is that if we don't future-proof the bill in terms of having a section on accountability, it would be a real missed opportunity. The bill would really benefit from having that kind of future-proofing to ensure that it's on the right track. We're on the right track in terms of keeping the promise.
Okay, thank you. Mr Ford.
As the bill, thank you for the question. The bill as it stands, the risk is that if it proceeds without the areas of strengthening that we've spoken about, that we won't address the drift and delay. We won't address the human and financial cost of that, and that we will, despite our best efforts, find that chronic drift and delay characterises too many childhoods. And I think that if it's not adapted, if this system can't adapt itself like we're debating at the moment, to meet the needs of those infants will miss that opportunity. I think there are a whole host of associated issues out there in the workforce, but I would say that we're aware that there have been some important steps taken in recent years that need to be consolidated and supported in terms of expanding the early years workforce and expanding specialism in the early years workforce. We would think that it would should be high on the agenda of IJBs to continue to invest in those areas, because prevention will help more than anything is to keep the promise for those who do end up in the system. And finally, I think the thing that I think we should all bear in mind is that there are real harm to real children if we don't provide them with what they need at the time that they need it, and that's a potential unintended consequence of the bill failing to grasp the nettle.
Absolutely, a very strong one. Thank you. And finally, Mr Hogg, is there anything you wish to add?
So in terms of your first question, which is about is this the right avenue, are you asking really, is this the right focus of the bill? Or are you?
Well, we're all agreed with the focus of the bill. It's focusing as a final, another step towards realising the promise which we're all signed up to and we all agree. But in your capacity, is the bill hitting the avenues correctly that you would see to get the bill to where it needs to be? Is it financially viable? And is there any unintended consequences that from your organisation you would be able to say, actually, this is where I think there might be a concern?
Thank you. Yeah. So I would echo what Matt said in relation to that kind of focus on early years and providing support when families need it. I think that there is a requirement to, that's what the promise said, you know, providing the right support at the right time and in the right way to people. I know that there is to be a lot of focus to come in relation to that, and that ability to provide parenting support and provide other opportunities like family group decision making would be helpful. But that's something that we would wish to focus on for the future. The issue around funding, you know, what I would say is that as you progress a bill and you see amendments coming through, undoubtedly there will be amendments which will impact on the funding. We've heard some proposals today around some kind of different roles that might be introduced into the hearing system. They would come at considerable cost, but also there are other resource implications in the sense of finding the people who can undertake that work. And I was encouraged by what Matt said earlier about seeing that some of those people with those skills are actually already being developed and exist.
Yes.
And just finally on unintended consequences, my only general point would be a lot of the provisions in relation to the hearings redesign require to be tested, and that testing is where you would find out where the unintended consequences might come.
That's very helpful. Everybody, thank you very much indeed. Thank you, Convener.
Thank you, and that concludes our evidence from our first panel of witnesses today. Can I thank you all for your time, for your answers and your contribution? It is much appreciated. And before we move to our second panel, I will briefly suspend the meeting for 10 minutes. Thank you. Okay, welcome back, and can I welcome our second panel of witnesses today. Lynn O'Brien, Chief Officer for Children and Families at Aberlour, Duncan Dunlop, Natalie Williams, Head of Policy and Campaigns, the Fostering Network, and Joe Derrick, CEO, Scottish Through Care and Aftercare Forum. Thank you all for your time today and your submissions. I started off with a very open question to the first panel, and it took us half an hour to go through it. So I'll try and be a bit more tighter in my questions. And while there are positives in your submissions, what I'm really keen to hear about are the areas you think the bill needs to be improved and developed, or what's missing. And I know other members will come on to that. So if you want to say the positives, please do. But the committee really has to scrutinise where this bill can be improved going forward. So perhaps, Ms Derrick, if we can start with you, any areas you'd really like to see the focus on improvements on this bill going forward?
Yeah, thank you very much. Thank you, committee. The area that I was understandably, as the Scottish Through Care and Aftercare Forum representative, will be most speaking to would be around about the aftercare provisions. So I think the membership of the organisation and the young people who have been involved in our work, the areas that they would particularly want to highlight is the importance of the early planning. So whilst there are aftercare provisions, and that's absolutely right, and in support of there being an extension of aftercare provisions, the areas that we would be highlighting are the need for there to be earlier planning, earlier stages of planning, more consistent planning and approaches across Scotland. And also in relation to that as well is that we recognise the importance of the relational approach that would need to be underpinning the implementation of this bill. I'm happy to stop there because I'm sure people want to expand on some of these points further.
Thank you very much. Ms O'Brien.
Yeah, likewise, there's lots in the bill that Aberlour would support. The key areas that we would want to see strengthened, a lot of the previous sessions have already covered that. The main points would be in relation to the alignment with the UNCRC. We agree with Together Scotland, we're members of Together Scotland, and we would want to see the bill upholding the rights of children and young people in terms of the UNCRC. Other areas we would like to see strengthened would be very clear guidance that would fall out of the bill. So in terms of just a point that's been made very well, the cluttered landscape around legislation for children, young people and families in Scotland, and ensuring that duty bearers understand children and young people and families' rights and entitlements, and that when we uphold one set of rights of entitlements that we don't create barriers for others across the sector. I think there's a key point in relation to the non-profit principle that we would like further clarity on, and to ensure that the non-profit principle upholds what the independent care review was really clear about, and that was that, as has been stated before, that no one should be making profit out of children's care, and we would support that, and we would want further clarity in relation to what we mean by profit and what we mean by surplus that's reinvested into children's care in Scotland. So I'm open to having a further discussion on that, but that would be a point that we would want to come back to. Yeah, and I think just hand over to other
Thank
colleagues.
you. Ms Williams.
Thank you. So from the Fostering Network, we really welcome the provisions in the bill for a register of foster carers, and it's something we've been campaigning for a long time, and I'm sure we think it's got a lot of benefits for children and foster carers, and I'm sure we'll come on to questions about that later. But in terms of what we think is missing from the bill, our foster carer membership, of which we have the majority of foster carers in Scotland are our members, and the majority of fostering services would be around foster carer finances, which are missing for the bill. Although we know that this isn't the reason why foster carers come to foster, but it's a really key area that needs improving in terms of retention, and there's nothing in the bill around either foster care allowances or fees, so we'd really like to see some amendments around those, and also around continuing care allowances for foster carers on that is also absent from the bill, and in terms of any kind of extension of continuing care for young people. So those would be areas that we'd like to come back to and like to highlight.
Thank you. Before I come to Mr Dunlop, these are all areas I know other committee members are going to delve further into, so it's useful to get that overview from you. Last week we heard from some of the witnesses that they felt there had been a lack of engagement in the lead-up to the bill being published. Once it was published, there was more engagement. Do you have similar concerns? Could some of these issues have been addressed if there had been improved engagement between the Scottish Government, be it ministers or civil servants, and yourselves? Or have you been satisfied with the engagement you've had on this bill? Ms Williams.
From our perspective, we have actually had a lot of engagement with the Scottish Government. We worked with them to hold consultation events. I think we have 10 across Scotland for foster carers and fostering services, so there was a lot of engagement on the fostering aspects of the bill. As I've said, there's some bits that are now in legislation, and I understand why those are in there, and I think it's sort of part of parliamentary procedure that, you know, the register's in there, so that's in legislation. But we understand that there are some other areas that are potentially going to be in a fostering strategy, because the future foster care consultation was a really wide-ranging consultation. It covered a lot of different areas, so we understand some of that will be coming later. But there are a couple of areas, which are the ones that are highlighted, which, as I said, we think are missing from the bill, and our members did raise with us. But I think we maybe had a slightly different experience to others in terms of that consultation.
Ms O'Brien.
Yes, Convener, yeah, I think it's widely recognised that there hasn't been full engagement in relation to the bill. But we would want to do all we can to make sure that we contribute positively to the process to make sure that it goes forward.
And Ms Derrick.
So we have had quite active engagement with Scottish Government throughout the past couple of years because we've been leading on a Moving On change programme, and as a result, a number of the findings that we had from that have also then been able to inform some of the work that's led up to the bill. And I would also acknowledge that for members there was a number of consultations they've been involved in that have also led towards some of this. I think there is a sense across the sector that there may have been more opportunities for engagement.
Okay, thank you very much. Mr Dunlop, I've deliberately left you to the last because you're not a big fan of this bill. And I was asking, the other panellists have a number of positive points and a few areas they'd like to see improvement. I read over your 4-page submission. There was very little you liked about this bill. Is that a fair assumption?
Yeah.
Tell us more.
13 years ago, in that corner, I brought care experienced people into this committee room. And it was the same committee with different people around the table. And that's where they first talked about the need for love in this system. And that cut right through the promise, the care review, and what we have as our rhetoric. Okay, and then they changed the care leaving age pretty quickly in the 2014 Children and Young People's Act so that people could continue to be cared for to 21. We were promised from that juncture onwards, and if you go back realistically, it was nearly 9 years ago when the First Minister said in front of thousands of people that we would rip up this system if we needed to do so. Okay? We had that commitment. And what have we had since? This is meant to be the marquee bill. I know it doesn't have promise in the title. It was meant to represent the transformation of children and young people's care. I was trying to think of an analogy to get us to understand what we are doing here. If you take it, the current care system, which doesn't work, and I'll come on to why I want to look at the outcomes for care experienced people, and look at the outcomes, where do they end up in life, not just how they're doing today, is a bit like a car that's broken down. It's on the bricks in the yard. And if you look at a car, think of it, the passengers in that car, the kids, they've got no option. That's where they're put. The state brings them into care. That's your vehicle. That's going to make the difference in your life. People who are trying to do the best in this, social workers, very well-meaning people doing their best, trying to drive that vehicle. Too often they get burnt out and they leave it too soon. What this bill represents is fixing a hubcap on that burnt-out car. What we need is across the road is an aeroplane that the community's built. It can be flown by someone who's going to hold that child's life to love, care and belong, and give them a sense of belonging forever. And it's got the freedom and flexibility to go where it needs to. This bill, yeah, it literally is like a colander. If you look at our current SAFE system with a load of holes in it, and this will plug one gap in it. So yeah, you can talk about the different bits of it, but will it deliver what those young people kicked off in this country and where we think we are globally in terms of leading with care experienced people at the fore? It's not. This is a sham if this is how as far as we're getting is transformation. And why this matters is the data and the stats. Look at the outcomes for care experienced people. They're all your constituents. We have had inquiries about Grenfell and about Hillsborough for the death rate, for what happened in those situations. But I guarantee since 9 years ago, more people who are care experienced, in fact I know this, have died prematurely completely from unavoidable deaths because we have not transformed this care system. And yes, they end up as our street rough sleeping homeless. Yes, they end up with severe debilitating mental health problems. Yes, they end up in our youth justice system. And yes, they end up prematurely dead within it. And I know we're meant to use more progressive language now, but no, because we've not got this as a society yet. And the solution lies in our communities, and it lies in all your political parties and this government, that we need to take this seriously and go, hang on a minute, this isn't good enough yet.
So given all the political parties have signed up to the promise, were supportive, you mentioned in your evidence that it's 3,256 days since Nicola Sturgeon made that commitment and got cross-party support. Why do you feel we're at the stage we are now, that the bill brought forward by the Scottish Government, it lacks any of the ambition you expect there to be? Given there is political will, surely that's the biggest thing the government need behind them. They've got the political will, the consensus across Parliament. Why have they not gone further in this bill, do you believe?
Because we haven't got the detail. If we actually look at what we're dealing with in terms of a promise, nobody's going to complain about the intent. Children need loved, right? We talked about that 13 years ago. But where's the plan? You need to do this by this date. You're the person who'll do it and it'll cost this amount. A civil servant told me that very early on in this process. Look for those indicators. And when you have that in broader strategic levels and down to operational plans at various stages, you then along the way have points in the journey you say we will need legislation to change X, Y and Z over a 10-year plan. We've never got that. We have a website still that's telling us what change will be. This is not acceptable. It really isn't when you look at the absolute human cost of this system and all those other social issues that we deal with and you care about in your constituencies. That's what comes out what goes wrong with care. And we could really do this differently and better, and it's time for a reboot.
Okay, thank you. There's a lot to get into with this bill with the panel today, and I'll move now to Pam Duncan-Glancy.
Thank you, Convener. Good morning still to the panel. And if I can turn again to Duncan Dunlop first, if that's okay. I think your evidence is really compelling. And the way that you've just articulated it is as well. There's a couple of issues that you've said would be real transformation. So one of them is to guarantee a care leaver a job within the public sector. Do you think that some of the things you've outlined, do they need to be on the bill, or are there other ways to do it?
I find it was quite ironic. One of the main people that did something around getting care experience people jobs, and they used to employ a lot, particularly in their first job, and they weren't necessarily work ready, but an employability scheme where they were just going to go through another training scheme as we classify positive destinations wasn't going to work. It's employed a lot of them. They're not work ready, but you enable them to become work ready. You teach them the culture of work, and it works in that way. The person who did this was, I can't remember her name, is it Dame White, who ran John Lewis. She did a huge amount around this. Why is it we're expecting the private sector to look after our kids? These are our children. We decided they weren't able to be looked after and loved within their own families alone. The state brings them into it. We own 20% of the jobs in this country. And the best you see is, yet again, social work teams or other charities focusing very much on this very difficult situation based on the trauma, offering them jobs. There's thousands of jobs. You know, whether we want to look at, I remember one of the best jobs I got was a guy in a recycling depot. It really suited him. But aspirations, there's education, there's in this building. The UK government does it for the civil service, have a fast-track scheme for care experienced people. Where is our ambition to say, if we want to give care experienced jobs, let's give them jobs? We are the parent of these children. Therefore, yes, there's housing, there's jobs, there's education, there's opportunity. The one area we've made progress is in further and higher education, to give credit. So, yeah, it certainly should be something we should do. And it's that level of ambition and will that matters. It's not trying to, we're worried about this, the resource cost implication. It will go. We know the life costs and then the financial costs if we don't do this.
And do you think, sorry to go back to the original question, do you think that we need amendments in the bill to achieve some of those things in education, housing and employment?
Yeah, that doesn't cover, really, I don't think, very many of those areas at all. OK. Do you have any suggestions on specifics, or is it something that you think that we should... Who should we engage with? How should we? Because the committee's job is to look at the bill, to listen to the evidence that we've heard, and to potentially recommend any amendments should the bill pass stage one. You can go back, as I was saying, it's quite arbitrary about what this bill's covering and what it's not. I mean, there's tons of stuff. I remember in 2012 we were looking at the right to return to care. We didn't go for, we'll go for that later, and we thought, no, we'll review the whole system. That still isn't in here. Yeah? The right to actually, we're talking about advocacy for those who have left care. What about for those in it? and you actually look at it very differently to give them a voice, there's so many things you can cover in this bill, but this lacks ambition. It lacks really the ability to be transformative. The promise will have the detail and the knowledge about how you could do some of these things. And my point is, they seem to not be engaged in the bill development, which I don't understand, because fewer civil servants will have written this bill than are paid for by the government to scrutinise it. So why don't we get them all in a room and say, come on, let's be more ambitious, and at least get something across the line before this Parliament ends next May?
Thank you. I appreciate that. I'm going to move on now to advocacy, if that's okay. Several organisations have commented on the extent to which the new right to access for care experience advocacy services in Section 4 of the bill would be shaped in secondary legislation. We've also heard that the potential for confusion with Section 18 on advocacy in the hearings system could exist, and respondents, including the Fostering Network, called for a definition of independent advocacy. Can I ask, perhaps first, I'll come to Natalie Williams, to talk about your understanding of advocacy and what needs to be on the bill and what can be left to regulation.
Yes, sure. So independent advocacy is a really important provision for so many young people in care and for so many young people that are supported by foster carers. We really welcome the introduction of the right to independent advocacy. And generally echo Who Cares Scotland's views on this that they were saying in the last session, and we support their view that independent advocacy should be defined in the bill, and we believe that leaving the definition to be set out in secondary legislation might delay this right being realised for care experienced young people, and it might risk the definition being diluted so it isn't truly independent. And yes, as we said in our written evidence, the Mental Health Act 2003 already has a definition, so we believe there's no need to delay on wording. This isn't a kind of our main area of expertise, so I think that's probably it for now.
The one, just if you don't mind, the other point on advocacy was the points around subsection 4.4, where I think you've said that we should ensure the right to advocacy can only be expanded rather than limited by secondary legislation. Can you expand a bit more on those comments?
Yes, so in terms of, we think that the definition of the bill can be more inclusive and contain at least some of the categories set out in the Scottish Government consultation on a definition of care experience, which was supported by the majority of respondents. So it should be defined as anyone who's been looked after, including at home, in kinship care, foster care, residential care, also including informal kinship care. So that would ensure that those people are able to access those rights, because at the moment the definition is quite narrow, so we think it should be expanded to include that, and that should be set out in the bill.
Thank you. Can I come now to Lynn O'Brien? I think in your evidence you've said that there are many professionals already involved in young people's lives, many of whom will consider themselves to be advocating for the young person. Do you see a distinction between some of those professionals and an independent advocate?
Yeah, absolutely, and we would agree with the points already made by other organisations, Who Cares Scotland and our colleagues in the Fostering Network. There is a need for independent and special advocacy, for sure, to ensure that children's rights are upheld. However, we also recognise that for some young people, they have a lot of adults in their life, and Fiona Duncan, I think, made that point as well in an earlier session, and therefore have to project manage and navigate different people in their lives. So we think that children and young people should have a choice, but also that people in the sector, so our workforce and duty bearers, should be better informed about the rights and entitlements of children and young people, so that what we don't have is a system where we're having to outsource independent advocacy to ensure rights are upheld, that actually what we do across the sector is that we uphold where we can at all points of care and support to our children and families, that we uphold rights and entitlements, and therefore when it's independent and specialist advocacy, it's really clear about what that is. But does support and advocacy go hand in hand? They're not either or, if that makes sense.
And do you think the bill needs to have that on the face of it or in regulation?
I wouldn't be that specific. I think that's up to the legislators to make that clear where that sits. I think we just need to be ensuring that what we don't have is a two-tier system where support and advocacy don't align, and then children and young people are confused.
Thank you. And finally, Joe, if it's okay, in your response you call for considerable additional funding for advocacy services to ensure they are effective. Can you tell us a bit about the capacity as you understand it in the system as it is, and the capacity that you think it needs to be?
I would say for our response around about advocacy, we would recognise that actually for young people it's the relationship that's important, that it absolutely spans throughout, and actually also from the young people that we are supporting, understanding their rights and entitlements is absolutely key, and that's not necessarily happening consistently now. So when we consider what the need is now, as well as what that additional need might be, then that in itself, we would suggest, is not going to be costed well enough. And that independent advocacy is about being able to have rights and entitlement. And a big part of our submission was about raising the voices of young people with care experience and who are also in conflict with the law. So they were also looking at the support from a legal perspective and understanding their legal rights from that perspective, as well as a process through care and aftercare, which can be very challenging for them if they don't have that information about their rights and entitlements. So from our perspective, ensuring that there is one person who is your biggest fan, your ambassador in terms of rights and entitlements, is something that we feel would be very strongly for, and that also can be supported and complemented by perhaps the through care and aftercare workforce and others who are also holistically have corporate parenting responsibilities. So to some extent echoing what Lynn is saying around about, it needs to be more than one person that's your advocate, but actually making sure and having the right to an advocate would be something that we felt very strongly would be of support, because relationships are key to being able to navigate what is currently a very challenging system to try and do yourself. We also know that our workforce can be challenged by what those rights and entitlements are, as well as young people. So I think there's something about the needs-led approach still for young people, and being able to have a range of supports that are able to support a young person, and for us particularly in that really crucial period of life, which is your transition to adulthood.
And do you have a view on whether it should be opt-in or opt-out?
I can't say that I have that from our members, so it would probably be a position I'd need to come back to.
Okay, no, I appreciate that. Thank you.
This was something, because I ran Who Cares Scotland, which is an advocacy organisation, and I was also the expert advisor to the English Care Review, did a lot on advocacy and its role, and it should be extended. It should be independent, relationship-based opt-out advocacy. And the way to think about it is, if as an adult you have a problem at work or within your relationships, you get a lawyer. A child in care going through one of the biggest often traumatic and transformational issues that can happen in their life, being removed from all that they know, doesn't necessarily have anyone alongside them. Yes, social work's working in their best interests, but who's really making sure their voice is heard? And if it's relationship-based, it sticks with them right through the journey, or at least the organisation will do that with them. So there should be complete continuity from when they enter care right through into adulthood. And we shouldn't be worried about when that ends. Naturally, they will not want that support to continue if they're given support of a loving, stable relationship. But it is opt-out. They have to understand what this means. Quite often, children and young people can balk at what the system's giving them. But you'll minimise relationships if we give an advocacy far more primacy and far more importance in terms of what it means within the system, and it can declutter the relationship. You could look at the role of reviewing officers that social work has had, because the advocate will be properly independent and properly mean that a child's voice and best interests are heard in every decision that's made about them, from living with a brother or sister to how they get on at school. It's a really important role, and it should go much further in this bill than it is.
Thank you. I appreciate that. Thank you.
Thank you. Miles Briggs.
I know you were listening to the first panel, and I specifically want to ask the question again in relation to aftercare. And I know the Fostering Network stated in response to our call for views that you felt that aftercare provisions could go further. So I just wanted to ask the panel what that would look like, and whether or not you think the Scottish Government are, and how the Scottish Government can adequately resource that. Natalie, I'll maybe bring you in first.
Yeah. So we support what's in the bill around the extension of aftercare to young people who left care before the age of 16, but we think that they shouldn't have to apply for it. And we'd recommend amending Section 1, Subsection 2 to create a duty on local authorities to assess a young person's need for aftercare up to age 26 to meet any needs identified. But we agree with others around sort of some of the resourcing that might be needed to be able to do this, and we know that already many young people don't get the support they need from aftercare. But I think in particular I'd want to use this opportunity to highlight continuing care and the kind of the lack of absence around that in the bill, and the particular areas of focus for us as the fostering network. So as Duncan said earlier, I think we would really support the creating a right to return to continuing care and seeing that in the bill. The promise supports that. We know that it's particularly an issue for young people who are in foster care and have to go to university during the holidays, and then after finishing have nowhere aren't able to go back to their foster carers. Other young people would be able to move back in with their parents. So linked to that, we would support extending the upper age limit for continuing care to 26. And yeah, so young people are potentially losing the support of their foster care of an adult that they've got a really trusted relationship with that matters the most to them at one of the most important points in their life. And yeah, we'd support extending that so that it was a right to return as well. And although it may not, I'm not suggesting that foster carers keep a room open necessarily for young people that in their care that may have gone to university, but if the young person wants to return and the room's available, then the local authority should be required to support them in continuing care, and that option should be available for them. And I think this bill sets out a lot of things, extending them to 26, but not on some of the really key areas that matter in terms of continuing care, and I think that we should be mirroring that in those provisions as well.
Would you see that working in practice? So I think for myself and probably most colleagues, some casework which I've had is that point at 16 when a CSO can be removed. Often that young person will either be encouraged or want to get out of services, and then the aftermath of that is not being able to take a step back into services. So would you see it more as an appeal process, or just that right and the principles of good transition should sit with this, that you would go back into services if you wanted? Because I think it's not clear in the bill kind of if it's an appeals process over this or how that would function. It's a long question. So.
Yeah, I think in terms of appeals process, that could be adding another complication to a system that would need a lot of resourcing. I think that it should be a right that young people have to be able to go back, and the system should be built around that in terms of those transitions and creating those longer transitions for young people and for them to be able to access them at those points, and the system supports that rather than having it as a cut-off point that then young people would need to appeal and all the kind of mechanisms that would go around supporting that kind of appeal. Yeah.
Okay, thanks. Anyone else want to comment on that, Duncan?
Yeah, I don't know if you've got children, Mr. Briggs, but if you do, or when you left home, you didn't leave your family. And the problem is with care, yet again, with our current system is, you don't just leave home, you leave your family. And that is a fundamental flaw of it. Having aftercare is literally a symptom of a failed system. To a large degree, if you go within most local authorities, it ends up being emergency aid and care. We're trying to keep a kid literally going in accommodation or food, whatever else is happening within it. So in that regard, I think North Yorkshire is a place, and we should, I know it's uncomfortable for government, but when you absolutely look at the way you could transform care, it will not cost us more money, not even in the medium term. And the thing you can do with it is they have a policy which is we are always here, and it's open door. If you need us, we are here. So it's up to the child or young person to dip in and out when they want the support. And they don't always come back for the negative issues or in dire need. They'll come back to be celebrated, to maintain the relationships, because it moves the psychology that I matter to somebody, even if it's a local authority.
Yep. Thank you for that. And I think last week we heard just the use of the word aftercare is problematic as well in this. So thanks for that. Anyone else want to come in? Yeah,
please, thank you. So I would actually just echo actually both parts of what have been said, because there's an element there around about the recognition around about continuing care. There's also about a right for a child to feel as if they're a part of a family, no matter what age they are. And that is what we've been all working towards, is about having a loving system and parents, corporate parents, that recognise that having made one of these massively significant decisions to remove a child and to place them within a care system, that they have a responsibility for life. And so that's part of why we would be calling around about that guaranteed lifelong support. Whether or not the right to return is key as well, and as we can see in trends in everyday life, that we are seeing that more and more people are having circumstances in life whereby they may leave home and then they come and return back home. And we've all done that, or we all know somebody that has done that, and that shouldn't be any different. We have can see some really good examples of support across Scotland that are working really well in terms of both the aftercare, continuing care, that right to be able to return. I guess the question is that it then becomes a bit of a postcode lottery, and we've talked about the postcode lottery for years within the work that we do. And so there is something that's nuanced in local communities being able to meet the needs of local people within their areas, as well as having an approach which recognises that we should essentially have a minimum standard, if you like, of what we would expect around about the lived experience of young people that we are caring for. So I don't have a view necessarily specifically whether it should be enshrined in law, but I think that if we leave it open to interpretation, then it's going to become one of these things that becomes resource-led once again. And if we can address the resource-led approach, and by mitigating against some of that, then it actually means that we can move more towards needs-led and being personalised in response, rather than having to make decisions that therefore mean that they have the right to. However, without it, a young person needs to know what their entitlement and what they should and can expect in relation to both aftercare and continuing care.
Yep. Thank you. I've got a few more questions, but I'll come back later on. Thanks, Convener.
Thank you. George Adam.
Convener, I'm glad Mr Briggs stopped here because he's already verging on the questions I was wanting to ask. But it's about corporate parenting in general, and I wanted to ask the fostering network, yourself, Natalie. We've already spoken about this to a certain degree, and it was given in evidence to us last week, you know, and I think Duncan's mentioned it today as well. With our own kids, 16, we don't just say there's the door, out you go to the big bad world, or if issues happen, 26, it's the whole life experience. You guys have said that in your evidence towards us for this. So can you maybe kind of talk to me about that and how we can actually get to that place if we kind of travel down that road?
Around corporate parenting. So I think the provisions that are in the bill around extending corporate parenting to cover formerly looked after children and young people up to 26 is really welcome. And I think we'd support Who Cares Scotland's calls for an even more ambitious approach, which extends the corporate parenting duties to cover care experienced people's whole lifespan. And I think that there's already a lot of bodies in Scotland that are kind of responsible for the corporate parenting duties, and in terms of sort of having that duty to be alert to matters which might affect young people's well-being. But I think there's more that I think we really need to enshrine this in legislation, that this support is there throughout the duration of those young people's lives, and then and up to 26. Yeah, I think that's.
How do we get to the place where the corporate parents actually understand their obligations? Because in a lot of cases, there'll be corporate parents, organisations and people. How do we get to a place where they understand what their current obligations are anyway?
Do you want to come in? I was going to say I'm happy to come in around about that. Guidance. It needs to be about national guidance. It needs to be about raising awareness. It needs to be about a training programme, and it needs to be a flexible but responsive approach across Scotland, because corporate parents across Scotland will have understanding of some of the responsibilities, but actually that needs to be held further to account, and one way of doing that is through more stronger guidance and through being able to demonstrate that in action. I don't think that there's a massive amount that needs to change necessarily in what those are, but it's actually about being able to see them being put into effect.
Yeah, because I said as a former councillor, we got this right from day one, you know, the corporate parenting aspect, and I'd find it strange if there was organisations that might be part of that that are not getting that. You know, I don't know what your feeling is across the board.
I think that there's inconsistencies, again, across the board. And that can be also within one local authority area. So if I was to speak on behalf of through care and aftercare teams, they cannot find times that within their own organisation they are having to either bring people within other parts of the corporate bodies alongside and understanding what the requirements are. There's also still too much stigma. I'm sure that we will all have experienced that. Young people who are still facing too much stigma around about being care experienced, and yet these are the corporate parents who have a responsibility for their welfare and their well-being. So I think there is something therefore around about still that inconsistency and how it is raised and how it is kept very high level, and some of that might be in relation to reporting and about actually being able to demonstrate where some of these best practice bits can be. But there is too much still whereby there is inconsistencies within corporate parents as to their own understanding and being evidence how they have actually been able to put that in place.
I'm almost scared to ask Duncan in case he starts shouting at me again right enough, because I know you're passionate about it, because I think I was on the committee when you were here with Through Care Scotland all those years ago. But just to talk about in general what we've talked about, you've no doubt got plenty to say with regards to this.
Sorry, Joe, no one to shout. Passionate about this.
No, I appreciate your passion for it.
Passion. It's not. It's a frustration and passion. The major issue with this and why this doesn't need to cost our country more, and the thing we've missed is who knows what care experience is outside of this room and outside of those people who work with them. I don't think very many people do. And I said, we've talked about this and we've had over 3 public announcements from the government that they would do something in public education on care experience, way beyond corporate parenting. You can think of the big seismic changes, George Floyd with racism. Even look at the post office scandal in terms of how we suddenly got attention on that. When you got something that cut through. Kathy Come Home was homelessness, you go back a few more decades. I said, what have we got around care experience that's going to cut through the public, that drives it, because it's an attitude. Yes, we can legislate for corporate parenting, it's already there. But how many of the plans are really followed through, and how many people checked as they're actually complying with what they've written down?
Do you not think, Duncan, sometimes it's down to the individuals involved in the corporate parent organisation?
Yeah, I do.
Because you and I buy into it.
Yep.
Others that have gone down the same kind of travel as me might not have bought into it as much.
Yeah, and there's a number of issues with that, but the good example of this and why attitude really matters is within the what's happened with further and higher education. There was a bill widening access. We need to get more people engaged. One of the groups we need to make sure that happens with is care experienced people. That was there. There was a tranche of money, and credit to the government for this, that they gave to invest in bursaries for care experienced people. But where that landed was in, I think, people with real authority and power with the universities, colleges and the Scottish Funding Council, etc., said, we can make this happen, we can make a difference. So they've had really open-mindedness to the way that they can change their own internal policies and actually treat care as a protected characteristic to make sure they get the year-round accommodation, to make sure they get the support, and if they need emergency grants, and really understood if they're missing classes, etc. So the attitude came from those who are the, I'm not sure we call them these days, and the principals, etc., universities and colleges, and it's been a huge uptick. With you get the policy and legislation, it was even legislation, it was policy, it was funding, and it was attitude within those institutions to make it happen. But the attitude is really key in this. And that's why the public education, which doesn't feel that tangible, really matters so people get beyond it. And one last point on it, I'd get rid of the word corporate parenting, get into community parenting. We're all part of a community, and if you care about this, it's with that hat on, not the corporate one, that matters.
Well, I think you make a valid point there, because it does sound cold, corporate parenting, and that's not what we're talking about. We're talking about love.
Yeah.
Thank you, Convener.
You're talking about love. It's a different side of you, Mr. Adams, I haven't seen before.
But it wasn't you.
I know, it definitely wasn't directed at me. Paul McLennan.
Thank you. Oh, that, I'm not sure. Kind of moving on, and it's more a general question. It's probably about the UNCRC. And Lynn, you touched on that, and I suppose some respondents obviously in drafting sections 1 and 2 on aftercare, and in section 10 on register of foster carers, and that amends the Scotland Act 1995. Now, this falls in within a pre-devolution UK legislation that falls out with the scope of the UNCRC. I just wondered what your views were on that particular point, because I think that's a really important point. It's maybe a small part of the bill, but I think it's, if we don't get this part right, it could create real issues. So maybe just come to yourself first of all on that one, as you've previously discussed that and how important that is.
Yeah, I mean, we would endorse Together Scotland's submission in terms of their proposal to amend the bill to ensure that the bill is compliant with the UNCRC and therefore doesn't specifically and only refer to the Children's Scotland Act 1995. And I think it relates to the bigger point around our ambitions for Scotland's children, and that we uphold and promote children's rights. So there must be alignment and connectivity with children's rights throughout the bill at all points.
Excellent. Joe, just on that same point, obviously, because it mentions about aftercare specifically, I don't know, on the UNCRC point, whether you've got any views on that?
Not further than the Together response. Thank you.
I don't know if anybody else wants to touch on that point, but I think that's an important point you mentioned. Lynn,
in there, if I can, just before you move on to other points, can I then ask Ms O'Brien, is your concern at such a level that should the government not accept the varied responses on this, that it does need to be incorporated in UNCRC and should be in standalone parts of the legislation, that the bill as a whole is then unsupportable? Are your concerns so significant that if people don't have that right of appeal through the UNCRC, then potentially the support for the bill overall could be under threat?
Well, I think in one of the earlier sessions, our legal colleagues were much more expert in terms of the actual technicalities of the legislation, but I think what we would support is that the legislation needs to be compliant with the UNCRC, and my understanding is that that's just an amendment that would need to take place.
So I'm not, and I accept that, and I think that is a legal question we'll definitely put to the Minister. If the Minister decides, because she's taken a decision already to frame the bill in such a way that there are elements that are out with the UNCRC because it goes back to the 1995 Act. If that is not rectified, would that be a significant enough concern for you to say, actually, we shouldn't support this bill?
I think it would be a significant concern that we would share with other people. What we need to see is the detail of that and what the children's rights implications in relation to that were. So I think it was Maria Galley, maybe, or the Kate from the Children's Commissioner's Office, who said that the children's rights, the CRIA, should be explored again. So we would need to look at that to see whether there was a massive implication for children's rights. But we do believe that there's a restriction in terms of the right to appeal for children and young people. So rather than going forward with the bill where it's restricted, we need to ensure that it's compliant.
Thank you. Thank you. Mr McLennan, back to you.
Yeah, thanks, Convener. I want to move on. I'll probably ask Duncan about this the first time. Some of the submissions to the committee said there need to be clarity on the bill's proposal for guidance in terms of relation to care experience and how effective they were, and you just kind of touched on that last time. There was also any views about who should be included in any proposed definition. I suppose it's how can the Scottish Government ensure that provisions have a positive impact on care experienced people, and how do you suggest work to decide on the definition?
I can't hear you, sorry, Paul.
How do you decide, how can Scottish Government ensure that provisions have a positive impact on care experienced people, and how do you suggest work to decide on the definition that should be progressed? And was one, I mean, I was like, George was a councillor for 15 years and also being the MSP, met care experienced youngsters and those going through transition. There was a real issue around about that particular point about what support they had and how much they were being listened to as care experienced people. And some of them had been in the system for a year, some had been in the system for 5, 10 years. But there was a real, I suppose the feedback was very strong that they weren't being listened to in terms of that more broadly. So I just wondered, in terms of just what you'd mentioned before in your previous point around about how can we get that definition of aftercare more broadly out there, and what are the lessons to learn on your background and where you are obviously just now in terms of what your views are?
I wouldn't have aftercare being age bound. I think we need to really get rid of that threshold. It's a psychological barrier, and as for not listening to children, it comes back to, I think, what I said earlier about advocacy. They don't feel listened to because, well, do they know how to communicate? You come into forums at formal meetings with people, and they're not necessarily that articulate in the way that we like to think about with language. That's why you have an advocate that's literally there to represent what they need, so they are properly listened to. Because if you miss something early on in that journey for them, then they stop listening and acting because they're stuck. You never listened to me about I want to be my brother, and I'm not. That really mattered to me. My dog mattered, my football team mattered, whatever it was mattered to me, and you didn't listen, and therefore I start losing faith in what's happening, and therefore we stop hearing each other. So it's really important that they're able to understand the whole machinery of care that goes around them. There is someone there to make sure that voice is represented. But again, with the aftercare bit, just get rid of it. It will not have the resource implication that we are scared of at this stage. If we have a proper system whereby we are committed to making sure people are being claimed, loved and belong to somebody.
Okay. Duncan, I've probably developed that. And Joe, probably looking obviously based on aftercare, the point that Duncan's just made, what your thoughts were on that, and obviously the definition of care experience, but the aftercare point is really important in terms of that. And again, I know we've had previous discussions about this in the past, but what your thoughts are on in terms of that in regard to obviously the bill and what we're discussing now.
Yeah, absolutely. So we would actually, and again, our members would support that actually, if we are able to support children and young people at an earlier stage, then there will not be the same need necessarily, if we do that line of correlation, will not necessarily need the same level of support, and therefore what aftercare will look like. So there are some things that are still about the scaffolding and actually what is in place at an earlier stage. And that's one of the reasons why we call for planning, when it does come to transitions to adulthood, to be happening in a way that is earlier, while still needs-led, but also that's consistently happening across Scotland. Aftercare as a term, we can use the term aftercare or not. The whole point is that actually that the young person who has care experience has a relationship with those that are responsibility for them, who will absolutely care and love for them, and that actually what we're doing is meeting their needs as they are transitioning into being an adult. And we are finding that that is not happening currently. And that's, I think, the main concern around about with how we look at the provisions in the bill is the intent is absolutely clear and one that we would support. Broaden the definition of care experience, but be clear about that definition, because when it becomes open to interpretation, then we start feeling that's where we start seeing entitlements and rights being not necessarily being expressed in an appropriate way so that young people understand them. And actually, again, is that bit of you can have less people needing to be around you to provide the support if you have been supported to learn and to be able to do that yourself, but not at too young an age, because actually we expect too much at times of children and young people based on cliff edges, based on age responses. So for us, I think there is, we said that it would be useful to have that mandated around about that definition of care experience. But actually what we recognise that as we are putting this forward around about definitions, about the provisions around about aftercare, is we have to acknowledge that it is not currently working as well as it could and should for young people. So therefore any further extension and any further additions that are being looked at and explored has to recognise the scaffolding that needs to be put in place, that the teams that are around about and the support that they have, that they are also more fully in place. As it stands, this could lead to having to look at eligibility, which also then means that we're back potentially into stigma. We're moving away from relationship-based practice. We're moving more into transactional. And I think if I could just bring back, I guess, there's one point that was being made earlier on in the question that Pam had, excuse me, for Duncan around about guaranteed the job within public sector. Whilst I don't have a view, and I'm not the one that we have with our members around about whether or not this is in the bill, if we can support our young people in terms of their finances and their ability to earn and be able to have a life whereby they have financial security and well-being, that will have a significant impact on actually their lives, but also about what the support needs they have as they transition to adulthood. So we need to acknowledge that actually there are other things that need to be in place and should be in place if this bill is then going to be effective in what its ambitions are.
Yeah, I think for picking up so far, Duncan's obviously mentioned about advocacy, and Joe, you mentioned about obviously the aftercare and so on, and the example I can use before was kids about 15, 16 who were ready to go in and have that transition. They had housing issues, but they also had a job, what's their next step in life. There was very little support in terms of that. Now, that could have been a huge impact if they get that start in life as against if they didn't. So I think the point you make is very important in terms of that. I don't know if anybody else wants to make a point on that, Lynn. I don't know if you want to. I suppose the other question maybe to ask yourself as well, Lynn, is around about the geographical differences, because depending on where the care is, where somebody is, it's going to be very different in rural Aberdeenshire or in Highlands or in Islands as against in urban Glasgow or Edinburgh. So again, I think that's a point we've not really discussed, but making sure there's not the geographical impacts that it might have depending on what care and support and advocacy is already out there.
I think just a broader point in terms of, obviously we're members of the Scottish Through Care and Aftercare Forum, so we'd support wholeheartedly what Joe's talked about. I think there's a bigger point that Duncan has referred to, as well as the cost of care, the cost of failure, that is really clear in terms of the follow the money report. So there's some limitations when we get into who's entitled, who's not, some of the restrictions that we put on that, whereas actually if we are as a nation saying that we want to do the very best we can for children in our care and who are looked after, then we do that. And this is what good looks like. We already know what good looks like. We know what children, young people and families have asked for. So that bigger point in terms of if we go down a reductive route in terms of closing down the restrictions, that there's a cost to that. Whereas actually if we are wider and much more ambitious, we enable children and young people to have better outcomes, and also we just reduce the costs that we already know are significant in terms of the cost of failure for our children and families. In terms of the postcode lottery, I think there's a number of points to that, and I think that goes back to the corporate parenting point, and that's about real understanding of the issues and connectivity and proximity of our corporate parents to children that they are responsible for, that they should love and care. And there is a variation across Scotland, and what I think we need to do is celebrate when it's done well and really talk about, as Joe was saying, you know, there are good examples, so let's see what that looks like, talk about the strong evidence that's there. We know things like some of the evidence that is emerging, that we're looking after less children and young people in residential care and more in the community. And what does that look like when it's done right? And what does that look like when it's in a rural setting? And what does it look like when it's in an urban setting? So it's some general points. But I think we do know what good looks like. We do know what good corporate parenting looks like. We know what good parenting looks like. So we should just do it and help others to do it too.
Yeah. No, Lynn, thank you. Yeah, Duncan, yeah, of course.
Look, I kind of think if you look at any human being, but particularly kids in care, or any human being, look at that prism, you need health, you need education, you need job or a purpose, and you need housing. And the one thing that will hold that together is a relationship. So although we're talking about matters with the relationship, it really matters that someone's holding, they really believe is committed to them. And the one thing I don't think is a good idea is that Wales did a universal basic income, because children and young people in care particularly need purpose. And if at 18 they're given a universal basic income, unless that's directly related to them getting a job and really being held into that, if they haven't got the skills and the social skills and the practice skills to do it, give them the job and work backwards from it. And therefore we all get our sleeves rolled up to make it happen. So it's a good place to start. We do some odd things in our care that we give them a flat. Well, not many 18-year-olds get their own flat. So again, we distorted this in a way that's saying, well, how do we absolutely get someone that's ordinary? But the main thing we've got to get is a relationship around that.
Yeah, I think that's a really important point. Right through this is an important part. But Natalie, I don't know if you want to add anything else at all.
I suppose from our perspective, it's just around some of the points I made earlier around the importance of continuing care and the possibility of extending that. Because we know that so many young people in foster care want to stay with their former foster carers but aren't able to. In our recent State of the Nation survey, 57% of foster carers that responded in Scotland said that they're worse off financially if they go into a continuing care arrangement. So that's a real disincentive for those young people to be able to stay. And those foster carers want them to stay, the young people want them to stay. But they're just not able to. And you know, in terms of the relationships and the support that those foster carers provide to young people as they transition, and as we've said, all the kind of the importance of the outcomes of those young people being able to stay in care and long-term outcomes that will benefit, you know, a lot less likely to end up homeless if they're staying with the foster carers. So we'd really like to see a statutory allowance for continuing care, because at the moment the allowance for foster carers, there's no statutory allowance for continuing care at all. So.
Okay. Yeah. Alan, thank you for that, Convener. Thank you.
Thank you. John Mason.
Thanks, Convener, very much. Ms O'Brien, you said you wanted to talk about profit, and so this is your chance now with me. I'm just looking at your submission. It says a few things. Organisations should not profiteer from children's care. And it also says the ability for a minister to put a profit limitation requirement on services could have a catastrophic impact on our ability to deliver high-quality care. So do you want to expand on that?
Yeah, I think there's a really important distinction here. It's the point that I made earlier, and that is that the care review was really clear about that point, that no one should profit out of children's care. And the distinction I think we need to make is that organisations who are providing care and support for children need to be, one, financially stable in order to do that and sustainable, but also that we don't conflate two issues here. We don't conflate the level of profit or surplus with profiteering. So when the care review made the recommendations, it was specifically in relation to the profiteering, the extraction of money out of the system that goes straight to stakeholders, the dividends for private companies. The issue in terms of surplus generation for organisations, we don't want to get into the situation where organisations are then heavily scrutinised and restricted, because what that does is it reduces the ability of organisations to respond in the best way to children's care and support. So Abelauer is an organisation that provides residential care and support for children, community support to enable children to stay at home with their families, foster care, etc. And every penny that Abelauer has as income is reinvested in those models of care, reinvested in children and families. And even greater than that, Abelauer, in terms of our primary purpose is to improve the lives and life chances of children and families in Scotland. So every penny that's generated through any income that Abelauer has goes to serve that primary purpose, which is very, very different from some of the private organisations who are profit-driven. I'm not saying
that would kind of argue then that everybody should be a charity, as we're talking about with fostering. Would that be an answer to that?
No, I think that is an answer, but I think there's a wider discussion there, and because there are some private providers who will provide high levels of quality care as well in Scotland, but they would reinvest money within children's services as well. I don't want to name any organisations.
Would you accept this is quite a hard balance then, the way you're describing it, to get that in legislation? On the one hand, we want to give the organisations freedom to invest where the need is, but on the other hand, we don't want to let them make too much of a profit.
I don't think it's about making, well, from my perspective, and I'm not a legislative expert, but I do understand the non-profit principle and the principle that we must do all we can to ensure that we deliver on the promise and improve the lives of children and young people. And for me, that distinction needs to be well made within the legislation. So if we're extracting money out of children's services in Scotland and it's going out with children's services, I think that's the area that we need to focus on.
Do you think the legislation, as we have the draft, is too vague? The bit I read out before, I don't know if you were here for that, but it's talked about ministers may specify how the level of profit made by types of persons is to be determined. I mean, that seems quite a vague phrase.
Yeah, I think we need to be really clear about what we mean by that in order that the legislation actually delivers on its purpose.
Okay. Mr Dunlop, you say profit's a distraction and we want love, but we can't put that in the legislation. I mean, the legislation has to deal with things like profit. Is that fair?
The reason I say it's a distraction is that, I don't agree with it. I certainly don't agree with it that people should be making money and it's going to, various hedge funds or whatever else in terms of where the money's being siphoned off to. But quite a lot of people make quite a lot of money out of this, and it's not just hedge fund managers or private care homes. In terms of, if you really scrutinise the accounts, some of the larger charities in Scotland, you'll find some quite eye-watering payments going to Scottish charities who deliver care in this country.
When you say going to charities, you mean going to the chief executive? And
yeah, basically, if you look at that. So none of the people around the table are decent to that. So none of us, in that boat. But the reason that I find it annoying is as a distraction. It's this sort of well-meaning bit around, let's focus on profit. I'd rather we focus on a type of care.
Yes, but we can't do that in do you accept we can't do that in legislation? That's the culture, that's the relationship you were talking about earlier. But this committee's looking at legislation.
Yeah, you can. But no, because what I'm going to tell you is I don't believe we should have institutional care. The care review and what's coming forth from that has not talked about residential care at all. There's 2 pages on it and fairly big text. It doesn't talk about it, and it's sat there at 11% of our kids are in it today. That's a huge issue for me, because you've got, therefore, a staff rota of 20 people trying to care and look after children. It costs a lot of money. Even in the public sector, they're spending between £300,000 to £400,000 a child a year to keep them in that type of institution. And when they come out of that, they're not held by love and relationships, and therefore it's a huge problem. So huge cost is going in, regardless of profits being made with it, but it doesn't work. We have to look at really what we're doing in terms of the type of care. And we have to look, therefore, if we're going to get people to love and belong and hold a child, a young person, they're not doing it for the payment. Yeah, they need their costs covered, and yes, it needs to, other ways in which their lives might be benefited from it, but they're not doing it for the payment. And that's why we have to look at the fundamentals of where we've gone wrong in terms of what we're doing with transforming care. It's a distraction in my mind looking at the profit question. We should really be looking at what are we actually delivering. Because if you looked at the fundamentals of who's trying to care for these children and how to enable and support them to care and love for these children, the profit question would diminish and wouldn't be there, because you couldn't make money out of it.
Okay, we could probably have that debate for quite a long time. Would either of the other two witnesses, Ms Williams or Ms Derrick, like to talk about this profit element? Yes, Ms Williams.
Yeah, so we'd like to come in on this. So we at the Fostering Network, we agree with the promise that there is no place for profit in children's social care in Scotland. Our primary concern, as others have said, there is the quality of the care that children receive. And
on that point, I asked the previous panel this as well, sorry to interrupt you, is there evidence that the care is better in the charity sector or the profit sector, or where?
I think there's evidence both ways, but I think that, as others have said, I think the fact that money is being diverted outside of the care system and that's not spent on providing high quality care for children is concerning. So we support the strengthening of the not-for-profit principle. We've been quite involved with the work in Wales that they've been doing around the Eliminate Profit agenda, and we support the proposal for IFAs to transfer to be registered charities in Scotland, and support that this is going further than they have in Wales. In Wales, they're just going to be not-for-profits. Some of our members, we do think that it should be introduced in a phased way to allow enough time for services to transition. We know that some of our members are already thinking about how they can do this. But we think that introducing enhanced financial reporting requirements wouldn't be enough to kind of address some of the lack of transparency around how IFAs operate financially, and that at the moment there are kind of loopholes that basically can be exploited. And that's what's kind of happening in Wales. But we do agree with Abel that in terms of charities should be able to reinvest their surpluses, and that's a key component of how charities. We're a charity ourselves, Fostering. That's how we manage to operate on short-term funding grants, and it enables charities to be able to be sustainable.
So the fact that we're dealing with fostering agencies differently from the residential care, do you see that as a problem, or is that just okay?
So we would support that Scotland should go further, as they have done in Wales, and require residential care to become not-for-profit. And actually the proposals in the bill are quite weak on this in terms of the sort of requirements that they require on this. So.
Okay, I'll just let Ms Derrick's not been in so far. Did you want to come in any of this?
Just briefly, similar to others, the overarching view of our membership was not consistent to be saying either way. What I would so therefore it was always about the quality of care for the child and the support for the carers, whether that be foster carers or whatever form of workforce or care. I think we need to, for us, we were also just recognising that actually in terms of the care for children within our care system, there is already a shortage of carers, if we're thinking about from foster care. There are roles for organisations to play, but actually fundamentally this is still about how we provide the best outcomes for children. But yes, we did not have a strong view as a membership about the position around about profit in this bill.
While you're speaking, I take your point about the best outcomes, and you said it shouldn't be resource-led in answer to a previous question. But do you accept that we have to live within a budget?
I think everyone is having to live within a budget, and also so do the other organisations as well. And I guess there's also about some of the long-term financial planning, which comes back into about how some services are supported in capacity to be able to deliver, which means that we can move away from some of the crisis interventions, which also then in turn means that sometimes some of the services that are accessed are in the sector in order to be able to respond to that.
Okay, Mrs. Dunlop, you wanted to come back in?
Yeah. If you look at a values ethical-based care system, why, if I'm going to place a child, but I want to place it in a profit-based institution, I would use Abalawa. You know, it's a charity, or use my own provision. So the question has to really be is why aren't we investing in choosing where we place kids, and why are we choosing to place it in those places? I don't see why we have to focus on the profit issue. It shouldn't be in our system. And my issue with this is why are we focusing legislative time on that when there's so many other issues that can make an absolutely transformational impact in children's lives that we should be focusing on? So yeah, it's an issue, but really why aren't the commissioners of care choosing different options?
Yeah, I think we're in danger of going over the same ground again, the culture as against the legislation. Can I come back on the fostering point, Ms Williams? You said in your evidence the average payment is £13,579 and it varies by £34,696. So at the top end, it sounds like some of them it's quite a lot, but
sorry,
the
is that
average
payments for placement and for fostering place?
Yes.
Yes, so
So it's varying a lot, and you'd like to see a standard rate?
Yes.
What would that standard rate be?
I'd have to come back to you on that to work that out.
Because it doesn't say in your evidence. It gives the average and it gives the variance, but it doesn't say what you actually want it to be.
Okay. I think our point is around profit potentially being taken out of the system, and that being money that's not being used for children's care and that's going to profit making. So keeping those as low as possible so that local authorities can keep their costs down and provide good care to children.
Okay.
But we can come back to you on that.
Well, that'd be helpful, thanks. And my final question would just be on the financial memorandum as a whole. The figure 20 to 23 million is what we're expecting to get to in 29-30. Is your feeling overall that that's a reasonable figure? Is it a bit too low, a bit too high? Ms Derrick?
Yes, so there will be, again, if I look specifically from an aftercare perspective, our concern is that the figure that has been calculated in aftercare for the aftercare provisions is unlikely to be enough, and that's in recognition of that there isn't currently existing enough in terms of support, but also, I'm sorry, I can't remember, I think it was... No, I'm sorry. I know there's been some other submissions that have questioned where the data has come from in order to do those calculations. And I think that we would support that. But in general, I don't have a figure of what it should look like, but we have a general sense that it was probably not enough for the ambitions.
Yes. That was my next question. What should the figure be that would like? I mean, it's going up to 7.4 million in 29-30. I mean, would it be double that or half again, or have you any idea?
I'm afraid I would also be coming back on that rather than guessing today.
That's fine. Does anyone else want to say anything about the financial memorandum as a whole? Yes.
Yeah, I think just to support that point around we need to be more ambitious for our children and families in Scotland.
On the aftercare and the advocacy?
All of it.
All of that. Right.
I suppose for us, just to, as we've said, there's key financial elements that aren't in this bill, and potentially we've not got the amount set out for those. So in terms of foster care allowances and continuing care allowances, that the finances need to be set aside for those, because we know that at the moment local authorities are paying well under, we're paying at the SRA, but we have calculated rates at the fostering network of what we think fostering allowance should be, and the current rates are sort of 50 to 100% lower than what we've actually calculated foster carers need for caring for a child in their care. A third of foster carers tell us that their allowances don't meet the costs of fully caring for children in their care. So we'd like to see the finances for those included as part of the bill, so that they can be included going forward.
Right. Final word, Mr. Dunlop.
No, no, I don't think I'll add anything more, Mr. President.
Thank you. That's great. Thanks so much.
Thank you. We'll go back to Miles Briggs.
Convener, I wanted to return to the register of foster carers, which is proposed in the bill to be set out in regulations at a later date, but just wondered what your assessment of these proposals was and how you think that can be improved. Natalie, do you want to come on that one?
So as I said, the Fostering Network are really pleased to see these provisions for a register and welcome that it's a pilot, because I think that allows some of the detail to be tested and worked out, and particularly in consultation with, we'd hope, with our members and other organisations. But at the same time, the fact that it's a pilot means that there's quite a lot of detail that's still not worked out, and we are kind of essentially talking about a concept here and what we think it can do. So in terms of the fostering network, we know that just over half of foster carers have said that they support proposals to create a national register. We think that it has 4 key benefits. for foster carers in the care system. Firstly, we think a register could really improve safeguarding of children. And we know that's something that the Scottish Child Abuse Inquiry outlined. Because at the moment when someone applies to foster, you don't actually know whether they've been deregistered for safeguarding reasons from another fostering agency. So this would allow you to be able to check that, because this is a real serious safeguarding risk to children at the moment, and we know from members it's something that can happen. We really think that it could improve matching and could maybe solve some of the issues that we've been talking about earlier in terms of allowing local authorities to have easier access to foster carers who foster for neighbouring local authorities. And IFAs, so it would be able to provide like accurate real-time data on the number and spread of foster carers in Scotland, which would really help with kind of the sufficiency planning for placements, because the care inspectorate data is always a couple of years out of date. We think that services could use the register to help find carers for children that they might be struggling to place. And we know that foster carers have vacancies, but sometimes we don't know where they are. In our last State of the Nation survey, we found that 44% of foster carers said that they'd had an unfilled space for a child in foster care in the past 24 months. So at the same time, we're saying that we've got a fostering crisis, there aren't enough foster carers, but actually there are some foster carers that are potentially have a vacant placement. And the most common reason they told us was they were waiting for a suitable match. So we think that a register could really help facilitate some of that around matching. We also think really importantly that would help keep children potentially more local to their family networks and their friends and their schools, which we know in the promise says is so important to children in terms of their stability. So in terms of knowing where they are. And then can also, so thirdly, help foster carers potentially transfer more easily between different services. Currently, services use different transfer protocols, which isn't mandatory. So this can cause delays if they want to move. So a register could help standardise that. And then fourthly, we think it could help go some way to improving the status of foster carers by giving them greater kind of professional recognition within the children's social care sector and among the general public. Foster carers are the only people who provide formal care for children who don't have to be registered with a central body at the moment, and they frequently tell us in our State of the Nation surveys that they feel that they're not respected in the team around the child when they go to those meetings. For example, childminders are registered, so that lack of respect and recognition perpetuates a sort of a lack of recognition of their commitment and skill when foster carers are looking after children 24/7 in their care.
That's really helpful and thorough answer. And in the previous session, we heard from Who Cares Scotland also a potential for a complaints function. Would you support that as well?
A complaints function against foster carers to be included in that.
Mm-hmm.
Potentially, if that was something that for children on behalf of about foster carers, potentially that could be something that was and particularly having that at a kind of independent level.
Does anyone else have anything they wanted to add on the register as such?
I think we would broadly support the proposal of a register. I think the second point is just around the detail, and the further consultation is required to really consider the implications of the secondary function. So if the first primary function is the safeguarding role, then we would agree with that. The latter parts we would need to fully consider the implications of that, and the complaints aspect would be one of those. So that's what we would suggest as further consultation.
That's helpful, thank you.
Could I maybe just,
sure,
just one final add in there. So from, again, from membership perspective for us, the register of foster carers would not be a specific thing that would be impactful given the nature of adult placement providers when it comes to continuing care. What we would just acknowledge is that there are a significant number of carers in Scotland who are then extending their registration and changing their registration in order to support children and young people as they become young adults, and doing that in a way which is about relationships and about supporting the needs of that young people, which is very different from where they started. That, I think, would also be something that might need to be explored further when talking about a register of carers, because that will also then have essentially a cut-off potentially around about the age bits around about that as well.
Yeah, thank you. And one area which I've raised with ministers previously, but panels as well, is around children and young people in kinship care. And you know, they kind of feel, to go back to your point, Duncan, we aren't being ambitious for that group of young people in this bill. So just wondered how you think that could be corrected. We obviously will have stage 2 amendments to be able to do that, but just wondered what your views was around specifically children in kinship care arrangements.
Well, Links think maybe Children's First wrote about this, but I think we should certainly have in the statute book around the right to family group conferencing, or the equivalent of that. So basically, you have to consider, before we use stranger care, which is what to a degree most foster care, residential care becomes, is anyone who has a relationship with a child must be considered as a caregiver before we use stranger care. An example where we get this wrong is there's been a plethora of mentoring schemes out there now, and they build quite great relationships with young people most of the time, but they're not considered as caregivers. And so that sort of thing really ought to be as a matter of course and what's happening with it. Another way to strengthen that is to give them co-parenting rights. Within foster care, actually, they're seen as a quasi-employee. It's a fudge. You could do the same with kinship care, or before, if they've been in their care for over a year, it's a stable, settled placement, then they should have co-parenting rights, and we don't do that.
Anyone else want to add anything on that? No, otherwise hand back to yourself. Thanks.
Thank you. I'm going to go to Jackie Dunbar and then Bill Kidd.
Hello, good afternoon panel. Thank you for coming along. I am going to have questions regarding the children's hearing part of the bill. The Hearing Systems Working Group recommended that the obligation for a child to attend a hearing should be replaced by a presumption. And the bill removes the obligation for the child, but it's not included the presumption. So I think Natalie and Duncan, the fostering network, have suggested that that could cause issues in terms of eroding a child's right to attend and the safeguarding of children's rights. So I'd like, if you don't mind, to hear more about what you think should be in the bill regarding that. You know, should a child be obligated to attend, or as can happen in the bill right now, or do you think that the bill should add just the presumption?
Yeah, so as we set out in our written evidence, we said that we support the removal of a child's obligation to attend a children's hearing, and believe that should be removed in all cases, and we don't think children should be forced to attend a hearing against their will. We think the presumption that children
in all cases.
Yeah.
Right.
And we think the presumption that children will attend should remain, except for babies and very young children. And we're concerned that removing this could erode children's right to attend. Just more generally on hearings and foster carers tell us that they're often excluded from children's hearings. And you know, as someone who spends a lot of time with the children, we think that the principal reporter should be required to seek children's views on who they want to be involved in their hearing. And you know, foster carers can provide a great deal of insight into children's needs. So foster carers can apply to be deemed relevant persons, but many don't know how to do so they don't realise that's an option. So we think that the principal reporter should be required to ask children who they want to be involved in their hearing, and that might increase the likelihood that foster carers are involved where appropriate and if the child wants them to be. So yeah, and we think that guidance should also be produced to support everyone who's involved in the hearing system to help understand foster carers' roles more, and communicate with them about the process of being deemed a relevant person.
Okay, thank you. Duncan?
Yeah, I mean, as it stands, then I would have it with if you had relationship-based independent opt-out advocacy, that will help cover some of that in terms of there's properly someone there to represent the child's view or perspective within that space. Presumption's better. But another point I'd look at is said, I think it's really interesting the way we're stuck with the children's hearing system. And I know we've not gone for the paid chair in the way that was initially recommended by the working group. But the family drug and alcohol court system in England, it is a resource-intensive process, but there's really skilled people in charge of that in terms of the judges that are running it, and they have really good outcomes in terms of reducing the number of children and young people that need to enter care. We have to recognise our hearing system was set up in the 60s under Kilbrandon, mainly for offence grounds, and now it's mainly focusing on children and young people who are in need of care and protection. It's a different setup. But I know we're not looking at that. It's a different transformation of a system, but I would therefore say if you're going to have that, it must be in combination with independent relationship-based opt-out advocacy.
Okay, thank you. And also there's been a fair few folk have responded to the call for views supportive supportive of the bill removing the relevant persons from the possibility of removing relevant persons from children's hearing. Got the ability to do so. You said in the calls for views that the bill doesn't go far enough, and the children should be at the centre of the decision-making process on if the relevant person gets to come in or not. Can you say a bit more about it? About that? Make sense of what I've just said, if you know what. Yeah.
No. Could you say it again, please?
Yeah, because that didn't really make much sense. You were saying that you're supportive of the provisions in the bill relating to the removal of relevant persons from children's hearings. You felt that the bill doesn't go far enough to centre the views of children in the decision-making process regarding relevant persons, whether they should be there or not.
I'm not sure that's my evidence, but I would tend to agree with the fact that I know there's certain issues around different people who've had, particularly if there's been domestic abuse within the situation, around who's present at all times within the hearing. I think what we need to be really focused on that is the hearing for the child. We are unfit child with the process by which a child comes into care. That's why I think we're always looking at the children's hearing system. We're going to look at that is how do we make sure that child is safely and able to be heard. And again, I go back to the advocacy element within that space. Quite often now I know that in the hearing system, more and more lawyers were coming in. It was more and more conflictual, more like a court-based system, which is not what it was ever designed to be.
Mm-hmm. So, in that regard, when the chair is... Because we heard from Sheriff Markey, I think, last week, that the chair already has that ability to do that. So, am I hearing correctly that you would like the child's advocate to maybe have? I was going to say more of a say, but I don't quite mean it that way. I mean to be able to maybe say in advance to the chair that the child does have. Some concerns, shall we say? Yeah,
I mean, the advocate is an extension of the child's voice that can be represented in a formal or, if you like, adult proceeding. So, yeah, they should have that ability.
Okay. Do any of the other witnesses have any views on that? My last question then, Convener, would just be if any of the panel has got any more comments on the remaining provisions in the bill relating to the children's hearing systems that's not been covered. What would you like to be covered that's not been covered, if anything? No.
Okay, thank you very much. We'll move to Bill Kidd.
Thank you very much, Convener, and thanks everybody for everything that you've covered so far. Now, I am going to ask a question which I did ask the previous panel, and if you were in the room, you'll have heard it already, but this is your opportunity to respond. And it's about integration joint boards. And the bill proposes that these will join local authorities and health boards on the list of bodies required to plan children's services. Now, I know that staff, Joe, I know that staff have said that a review of this existing guidance should be taken in place before any changes are implemented, and that nationwide support should be standardised. Is there anything further that you would like to say about that, in particular about the involvement of integration joint boards?
Beyond what we've said in our submission would really just be again about that we bring this back to the lived experience of people who are in that system. Right. So therefore, when we're talking about that unified national framework, it's also about that young people understand what is available, what they're entitled to, what their rights are, and that therefore that we don't, it tries to reduce some of that different lived experience based on where you live. Right. And that actually that also supports the workforce as well. There are still too many people who don't know what the rights and entitlements currently are, and that's why alongside thinking around about this bill and making sure that it is one that is empowering of young people, children and young people, because ultimately we've been talking around about them, but ultimately this is about the empowerment of young people so that they are informed in their own lives and their ability to flourish within their lives. For us, there really is about ensuring that the guidance that comes underneath the implementation of anything that is passed within this bill will be absolutely key to the successful outcomes. And therefore, that's where we would be looking at. Let's be clear that actually there's a lot that's already well known and already there. And let's not get caught up in what other things might happen if actually there are things that need to happen now for young people.
Okay, so basically it's about consultation with those who are most affected is the most important route to begin with before you look at all these other elements.
There's consultation and there's movement into co-design, and that's a big part that is sat underneath the work of the Promise and all the organisations that have been around about this as well. If we're able to make sure that those who are involved, who this impacts on the most, actually we get to better solutions.
Okay, thank you. Natalie, I think you look as though you wanted to say something there.
No.
You didn't, sorry, I beg your pardon. Duncan, anything at all?
I think it's one of the major areas, again, we've missed the boat with, and we have for 8 years. Nobody's talked about who should deliver care. Who should be overall responsible for this? We've had no conversation about that at all. Why is it sat with the local authority? And oftentimes, and I've heard this, I was the expert advisor to the English Care Review, and I did it in New Zealand too, is a finance director of a local authority has a lot of power in this if they get it and if they prioritise it or they don't. And therefore, and look what they're in charge of. Flower beds, potholes, and children in care. It doesn't make sense. In terms of why is it being held in that way at that level, and there's whole issues around local authorities or efficient administrative bases. But if you're looking, and again, it's the culture and it's the emotion, you're trying to get a community to own these children and young people. It's at high school level, a GP surgery kind of level, we need to be organising and looking at how we deliver care and get your community involved. If it's at too broad a level, it's too detached from the people who can really understand and care about a child and the family and who's around them.
Okay, well, that makes sense. Thank you very much. And Lynn, do you have anything you want
I
to
think it just relates to the earlier point. We didn't make a huge point in relation to that part of the bill, but I think it relates to the earlier point in terms of the culture. The structure will only take us so far, but the culture will take us further. So I would rely on experts to comment further on that part of the bill.
Okay, well, thank you all very much indeed. Thank you.
Okay, thank you. And finally, Willie Rennie.
So, Duncan, I'm going to direct my questions towards you. I mean, you've expressed your frustration verging on anger this morning about how things have progressed. What I would quite like is what we do next, because we are going to be considering stage 2 amendments, and we're not going to be able to go back to the beginning. We are having to deal with what the bill is before us today. So I would quite like for you to set out from your experience in England and also here what you think we should precisely do. Now, you may not have all the answers just now, so you may be able to make a submission later, but I would like to know what we do, because we get how frustrated that you are, but what do we do next is my question.
Okay, well, there's one point on this that I think your committee took evidence from, probably in the closed session, within the last couple of years from care experienced people. And I think you should, and I have issues around this. I understand my absolute background in youth participation, engagement, lived experience. And I have a problem with the phrase co-design. And a lot of activists I know who are care experienced and they work in the sector in different places say, there's a real problem with that we're being used as tools to prop up this status quo and this failure to actually deliver change. Their job is to say, this is my experience and I'm not enjoying it, it's not good enough. Or this was my experience and it wasn't good enough and I didn't enjoy it. And okay, this is what I should have had. But why are you asking me to design what that should look like and be different? And I was given, there's two examples given by this by leaders, and there's one is Johnny Hoyle, who said, if you give me lasagna from a tea every night, all I'm going to ever ask for is lasagna. I don't know what else is out there. And the other one was given the example around being in a train. If I'm a customer and I get in a train, Edinburgh, Waverley to Glasgow, and it doesn't work on time, or it's uncomfortable, too hot, whatever else, I say that was a rubbish experience. It was too hot, it was uncomfortable, I didn't get what I wanted. And you expect somebody else who's got the expertise and the knowledge and know how to fix it. And they can come back in when you say you fix the carriage and go, yeah, that's it, or that's not it. But the way we are trying to say everything's around them and they're designing it, it's all okay, that is not okay. It's become a smokescreen for us not scrutinising what's happening enough. Hear the raw experience. You will hear from care experienced people what's going on for you today. in terms of guiding what's happening, and this committee can do that in its future iterations. In terms of what you can do, one thing that comes to mind really in this was, yeah, you can have some marquee proposals in this. Get rid of an age limit on aftercare. Okay. Don't do it. Just say, we should always be there for these kids. We've taken them into care, and people always say you cannot legislate for love. But by heck, we legislate to say you're not able to love your child, and we can remove them. If you're able to do that, we should be able to say, this is what that does. How do we create the best conditions for you to be loved and supported and cared for? And where we don't succeed with that, and it will never be a fail-safe system, we'll never get it right for 100%, we can do a hell of a lot better with it. We can say, we didn't get it right for you. Therefore, a lot of these proposals, in terms of giving you advocacy for life or the college university provisions, everything else that's already actually there, is saying, we will keep offering it to you because you are our child. And if we recognise that and we make that statement that you are our child and we will not leave you, even if you want to leave us, that's okay, but we are always here for you, that would be a very good psyche with which to look at it. And if you're wanting specifics, I wrote some down within that space, but I could go away and give more thought to it. But I think we need to be far more ambitious in terms of lifting our head up, in terms of saying, we're in the weeds dealing with what this is. Let's go ambition with what we could do with this and take a bit of a, it might feel like a risk, it's not. It will absolutely send a really strong message out to care experienced people that they absolutely matter, and not just a few we hear from, those who are living lives on a daily basis, who don't want to necessarily wear their care identity on their sleeve.
If you were able to send us that, because we have to deal with this bill, and I want to make this bill the best we possibly can. So that age limit, one, let's work together on that. If there's others that you've got...
You had the right to return to care. We should have had that in 2012. In regret, we didn't do that. The stuff around employment, I mean, I can give you the issues to bring forward, but I wouldn't be so vague as to do what I think this bill is, which is just to randomly select things.
Okay, fine. Thank you.
Thank you all very much. That concludes our evidence session on the bill today. I'm grateful for your time and for your insight, your contributions to this important part of the parliamentary scrutiny. And that also concludes the public part of our proceedings. The committee will now move into private session to consider its final agenda item. And to allow our witnesses to leave, I will briefly suspend this meeting.